We want to welcome you all to this webinar. I want to make sure all of our members know that normally this group meets and we do these presentations to our brokers and managers about once every quarter. And it's usually open to brokers and managers of offices because it's usually the high-level legal issues going on in our industry. But we decided with all of the very important issues going on in our world right now due to COVID-19 that we open this up to all of the members since we have that opportunity with technology. So we'd love your feedback on how you're going to enjoy this today, and please send, whether it's comments today or directly to PWR after the webinar's over. We want to know how you enjoy this and that this is something that you might be interested to see happen more often in the future. The topics that we're going to cover today, the main point of this webinar and what this was scheduled as a meeting to begin with was for a deep dive and clear explanations of the new clear cooperation rules with regards to CRMLS. And if you don't know the background on that, that's the NAR 8.0 rule that you've heard a lot about over the past couple of months that the directors passed last November at NAR. So that was the main intention of today's webinar, but it's turned into not only that will be the main point of the webinar, but also an update on COVID-19, what's going on with the disclosures, the forms, the rules, all those types of things we'll cover. And quite frankly, any other PWR issues that you guys need to talk about. You've got some of the best and brightest minds in the industry on this call right now. So please use the Q&A box for your questions. Please avoid using the chat box. The chat box gets very confusing. Please direct your questions to the actual Q&A box. I'll be monitoring those and I will help facilitate those to our panelists when we are done with our opening remarks. So again, we'll go through a few presentations first, get all your questions in there, and we'll be sure to address as many of them as we can. If we can't address your question, I promise you that PWR will compile answers to those questions if we don't get to those today. So I want to start by introducing who we have here with us today. First and foremost, we have our amazing CEO of the Pacific West Association of Realtors, Mr. Phil Hawkins. I don't know where he is on your screen, but he's to my left. We have Lori Smith, our amazing Director of Professional Standards here at Pacific West Association of Realtors. And then we have our fantastic government affairs team of Tim Shaw and Christine Schachter. If you don't know, they're known as the beauty and the brains, and I'll let you figure out which one you think is the beauty and the brains. It's probably different than you assume. We have Ed Zorn, who is the Vice President and General Counsel for CRMLS. And last but certainly not least, we have Mr. John Giardinelli, who is our Association Counsel for PWR. And if you don't know me, I am the Vice President at the Pacific West Association of Realtors, and I typically moderate this panel in the room at PWR to mostly keep these attorneys in line because they like to talk. So that's why I'm going to be helping moderate the Q&A today. So to start, we're going to kick it off with Phil Hawkins, who's going to give us a PWR update.
Thank you, Barbara. So first, I want to welcome everybody to the call. It's I don't know if you were on earlier when Ed and I were talking, normally when we have this at our office, we have 50 or 60 people that attend this event. It's nice that we're about 500 right now, and that continues to tick up. So we're actually touching more people and getting more information out by having these Zoom calls. So you never know, this might be the way of the future. Buy some Zoom stock, I guess, or maybe it's too late. I want to start off by saying we are open to serve you. We are open 8 to 5 every day, Monday through Friday. We're even open on Saturdays from 9 to 1, and that is by calling us. Give us a call. We're able to do almost everything over the phone. The only thing, one of the only things we can't do over the phone is provide you products, but we still can provide you products. We'll ship them out to you. And in the likely event, unlikely event where something's too big, say you want to get a yard sign or something like that, we'll arrange for pickup at our office by appointment, and we'll figure that out. But we're here to serve you in any way we can to serve you. So give us a call. We are still getting over 200 calls a day. We're averaging around 250 calls a day on a variety of topics. So I know a lot of you are using that. We have 12 full-time people answering the phones. They are all located at home. So, but they're able to do everything from their house as they were doing when they were physically at our location. So again, we are here to help you. We are here to service you in any ways we can. So feel free to use us. Like I said, we are getting a good number of calls every day. So continue to do that. I do want to mention that, we have stepped up our communications with our members. We are doing 2 to 3 Zoom calls a week. Whether it be like this Friday, almost every Friday, we're doing the Barb and Ray and Steph live, the Facebook live. So I encourage you to log on to those on Fridays. We're usually doing something during the middle of the week like this. We do have something coming up in the middle of next week. I'll mention it shortly. So we are doing 2 to 3 calls a week. So feel free to log on and watch us as we will. This is it's changing regularly. I mean, it's changing daily, if not hourly, as far as what's going on in our industry, as well as what's going on in our state and our nation. So feel free to log on in any of those. We have moved most of our education classes online. And we're working with the instructors that weren't set up for that. So going forward, you're going to see a lot more options online. And even when this passes, we're set up where we're going to be offering, if not all, close to all of our classes. We'll give you the option whether you can come in physically or you want to watch it at home. We'll have that option for, again, if not all of our classes, almost all of our classes. So we are changing with the times when it comes to this as well. I would encourage you to visit our website. On our website, right in the middle, there's a big red line, and it says important information regarding the real estate industry and the COVID virus, and it says click more. So we're updating that when we get information. So that should be a great resource for you to use when it comes to what you can and can't do in our business. And Christina and Tim are going to talk a little bit more about government affairs and what's happening in our communities. I do want to stress something that you should have received an email last Monday, which is today. Today's Wednesday. All my days are going together now. On Monday, even though all this is going on, we have to continue going on as well. And it's this time of year where we have our board of directors applications are out to our members. If you're interested in running for our board of directors, we have 4 spots available for our 2-year terms, and we have 2 spots available for our 1-year term. And the 1-year terms are designated for if you've never served on the board of directors at a realtor association. Those are available to you and only to you. So we always have 2 brand new people every year on our board of directors, if not more, but we always guarantee at least 2 brand new people. And I would encourage you to look at your email and fill out that application, or go to our website. And once you sign in, it's on our dashboard where you can fill out an application or run for our board of directors. And please, if you've ever thought about it, and that'd be a great time. Because it's right there for you. It'll take 5 minutes to fill out. We are more than likely, I would say it's almost a guarantee, we are doing interviews via Zoom. So you won't even need to come into the office to go through the interview. We'll do that from the comfort of your home. So for those that don't like the interview process, it's much more comfortable when you're sitting in your own home for that. So
Phil, can I jump in here for a second about that? I don't know that that's fair, because I had to endure going into that large conference room with all of you scary people around it the first time I did it. And I would just highly recommend to my colleagues out there and friends, please, if you've ever been interested in leadership, or you want to give back, or you want to make a difference, now's the time to do it. We would love to see some new faces. I can tell you, and those of you that know me know that this has changed my career by volunteering and giving back to organized real estate, not necessarily because you get anything special out of being a director, but what you do get is you become a better practitioner and you become a better steward of our industry. And I can promise you, you'll learn a ton, and you will have a ton of information to take back to your teams and your offices. And it's been a fantastic part of my real estate career. So I highly encourage, if you're nervous at all, just fill it out, and you get to be lucky and only have to interview via Zoom. So
thank you, Barbara. And that might be a way of the future. Maybe we do this going forward. So, but yeah, take a look at that if you considered it at all. And if you haven't thought about it before, think about it. Applications will be accepting them until the 22nd. I believe that's a week from today. You still have another week to fill that out. So strongly consider that. I already mentioned before, but I want to plug it again. On Friday at 1 o'clock, we have our Facebook Live that we're doing with Barbara and Ray and Stephanie, and they allow me to be on it during this time. And I do want to point out, ever since I've been on it, their ratings have gone up. We have a lot of reviews happening since I've been on the call. So I appreciate my fan base out there. So thank you for that. The other thing I want to mention is next Wednesday, the 22nd. I did mention that's the day that the applications are due for the board of directors. We are also hosting a economic outlook. That's actually being hosted by our YPN committee. They arranged to have an economist come in and give us what this person's seeing, but it's open to everybody at PWR. Although YPN has arranged all this, and watch your emails for that, as well as on our website. Again, that is next Wednesday. And then finally, we have our annual agent summit that was originally scheduled for the I think it was June 2nd. And with all that's going on, we pushed that back. We are still planning on having it on July 17th. So mark that on your calendar, save that date, and we'll keep you posted on if there's any changes with that. But we have moved that back from June 2nd to July 17th. So I think that's about everything I have. I'll be hanging around if there's any questions that come up. But thank you, Barbara, and we're looking
Very welcome. All right, now we're going to hear, Lori, do you have any updates from professional standards that you can share with us?
Yes, thanks, Barbara. And thank you, everyone, for joining us today. I'd first like to let you know that the Professional Standards Department is continuing to process all of our ethics, arbitrations, mediations, and red complaints. So please do not hesitate to file if you have a concern, or you can certainly call or email me directly if you have any questions on how to file a complaint. Yesterday, I spoke with Carlo H. Banke, who is a special investigator with the Department of Real Estate, to see what's going on throughout the state. And he said that thankfully they have not seen an increase in any kind of real estate related crimes or frauds in the past month. So that's pretty good news. But Craigslist is another story. Please contact me if you hear of any Craigslist rental scams. It's not uncommon for someone, probably not even licensed, to list your seller's property as a rental on Craigslist and request that that potential renter wire their deposit money directly to the scammer. So this type of fraud is something we can work on with the district attorney's office. So contact me immediately if you hear about this kind of fraud, and we can jump on that pretty quickly. Let's see, the DRE has launched an email feature that I thought you might find helpful called Ask DRE Licensing. They will answer any questions that you may have pertaining to your license or your renewal. And the DRE's office is open and running, except that it's closed for members of the public. And of course, you can get more information from the DRE at dre.ca.gov. One of the more common complaints we're hearing about right now is agents who are farming or leaving promo materials at properties. So with this stay-at-home order, please refrain from farming or, of course, holding any open houses. The National Association of Realtors has informed us that the timeframes for filing any complaints will not be affected by the stay-at-home order. So keep in mind, if you do want to file a complaint, it must still be filed within 180 days from close of escrow or date of reasonable discovery. So with all these changing orders and government recommendations, where does NAR's Code of Ethics come into play? Well, to be a violation of the Code of Ethics, a violation of the stay-at-home order must involve conduct directly addressed by one of our Code of Ethics. So in other words, you could be in violation of a stay-at-home order, but not necessarily in violation of the Code of Ethics. So your Code of Ethics, of course, doesn't address every aspect of your business life, but it's there to make you become a better realtor and hold you to a higher standard. So to determine if a stay-at-home order was a violation of the Code of Ethics, a hearing panel would look at the actual conduct that occurred and determine if a specific code was applied. Some code of ethics articles that might apply to conduct in the COVID-19 environment would include a violation of Article 1, which requires fiduciary duty and honesty to all parties. Article 2, the disclosure of property conditions. Article 3, which requires cooperation with other agents and access to property. Article 12, this article means you have truthful communications in your advertising and all your representations. And then Article 16, of course, respecting the exclusive representation or exclusive broker relationship agreements that other realtors have with their clients. So, and now would be a good time to take advantage of the Code of Ethics training that's available to you online through CAR, and also maybe check out some designations that you could obtain through NAR, at realtor.org. I thought this would be a good opportunity just to review some of the programs we do have available to you as a member that you might not be aware of. One is our Ethics Advocate Program. If you need help preparing and writing up a summary for a formal disciplinary complaint, or if a complaint has been filed against you and you need help responding to that complaint, or maybe you just want another realtor to attend the hearing with you, an ethics advocate is a member of a professional standards committee and someone who has volunteered to help you through this entire process. A disciplinary complaint. We encourage you to file a disciplinary complaint when you feel there was a violation of the Code of Ethics or an MLS rule. You would first prepare your case with a written summary, laying out the Code of Ethics and MLS rules you fear you were violated, and then you would present that to the panel at a formal hearing. And then both sides are given an opportunity to state their case. And after listening to testimony from both sides, the panel then can impose disciplinary action if they find the respondent in violation. We also have our Rapid Ethics Delivery Program, or our RED program. This program was created by Pacific West about 10 years ago now, and we've had great success with the program. You can file a RED complaint, for instance, after you've tried to maybe resolve an issue with that other agent and that other agent is not cooperating, or maybe you're not quite ready to file a formal complaint, you just want the issue resolved quickly. The PWR staff will reach out to the offending agent and try to assist with just a quick resolution of the issue. This program in particular is unique to PWR, and it's received national recognition, so we're proud of that. So when would you file a RED complaint? Well, one of the instances where you might file would be lack of return phone calls or emails or text, missing paperwork that you need in order to close your file, misleading neighborhood market reports, using another agent's photo for advertising, not presenting offers, and maybe flyer violations. So when these come in, we track all these calls, and if we see a pattern developing, we'll take that complaint to the grievance committee for the recommendation of a full hearing. And a grievance committee member would then actually act as a complainant, so you don't even have to attend the hearing. Arbitration, all money disputes are handled through arbitration. So an arbitration can be filed when there's a monetary dispute between two agents, which is usually over a commission issue. Both parties have an opportunity to present their cases to the panel, and the panel will make the final determination, and they can issue an award if they find in favor of the complainant. One of my favorite programs that we have is the mediation between buyer and seller. So if there's a monetary dispute between a buyer and seller and it's over $10,000, which usually is the return of a deposit or a lack of disclosure, mediation is required in the terms on the RPA. So mediation is always just an attempt to settle this dispute between the two parties. So we have a team of experienced brokers who can help the parties attempt to reach a settlement and get it resolved, which will then keep that dispute out of arbitration, because arbitration can become extremely costly very quickly, usually over around $6,000. So Barbara, I mean, I have nothing else right now, but I welcome you to call me. If you have any questions at all, I'll be happy to answer any of your questions regarding filing or any other questions that I can help you with. I'm happy to do that.
Thank you so much, Lori. We appreciate you. Now on to our esteemed beauty and brains. Do you guys want to reveal who's the beauty and who's the brains?
Well, I think you can tell by who's up front, closer to the camera.
It's true, I'm the beauty here. So Hello, everybody. Thought I would start off giving a little highlight on national, then state and local issues. So at the national level, NAR has on their website listed a few, it's called Right Tools, Right Now Initiative. So you can get a lot of information on this site. There's a whole section for coronavirus advocacy FAQs, what NAR is doing to advocate for us at this time. Mortgage and personal finance FAQ. There's an SBA CARES Act FAQ. So the part of the stimulus bill, they call that the CARES Act, if you've heard that. And then the pandemic unemployment assistance FAQ. So a lot of good resources there at the NAR website. I was going to mention too, I saw the headline yesterday, the federal government's deficit for just this year alone might end up approaching the number of $4 trillion in deficit for this year. It's with all the revenue that's declining and the government spending that's going up, we're ballooning the deficit maybe up to the number $4 trillion, a truly shocking amount of deficit for 1 year for our country to go into, but that is maybe what they're saying. At the state level, Governor Newsom, under the emergency powers he has as governor, has issued a few executive orders that would relate specifically to real estate. For those who own their home, there was a executive order issued on March 16th that said that there would be a 90-day forbearance on mortgage payment if you were being affected by COVID-19. That would have if you were to take advantage of that, there's no negative implications to your credit rating, and there would be no fees or charges based on that. And there's, in this period, a moratorium on initiating foreclosures for this period. So that was a March 16th executive order. On March 27th, there was an executive order related to those who rent their home, saying that there is responsibility on the part of the tenant. They have to declare in writing to their landlord that they will not be able to pay rent, wholly or maybe even partial rent, within 7 days after the rent was due. They are also supposed to retain documentation as to why. So that was at the state level. Governor Newsom held a press conference yesterday, if you didn't catch it, kind of talking about what it's going to look like when the state reopens for business. It frustrated everybody because he didn't give an exact date or deadline, time frame to work with, but he sort of had under the umbrella, he wants the state to be able to test, trace, and treat those who are getting COVID-19. So once he feels comfortable that the state is able to test, trace, and treat, he will reopen the state. Just listening to both the governor and President Trump, it seems that President Trump is very anxious to lift the federal, shelter-in-place orders and stay-at-home orders, but we might see some of the governors are not as gung-ho on that idea. So there could be down the road maybe a difference between what our state's doing versus the country as a whole. We'll have to watch that one. At the local level, LA County Board of Supervisors has made some interesting policies. So there's an assistance program that does largely mirror what's happening at the state with no evictions due to inability to pay rent and no late fees and all that. But they did put a specific time period at LA County that a renter has 12 months to repay to make good on the rent that they maybe skipped. So the tenant still has to make good on their payments, but they're kind of given that 12 months to do so. And also the LA County said you can't penalize or in any way evict or anything your tenant if they now have additional occupants living in the property, or even pets are now allowed in. So that's part of the emergency there.
Hopefully John paid attention to that. That's a big one. Pets, you can add more and more. Emotional support. He's on mute, so we can't hear him. That's okay. I'll go ahead and talk about the CARES Act.
Yes.
Which Tim referenced. Two big things coming out of that. One, the expansion of small business assistance programs. There's 3 key ones under that. The Paycheck Protection Program loans, again, the PPP, Paycheck Protection Loan Program, that's really going to apply to a lot of our brokers who can get up to 10 million in terms of loans based on their filings from last year, 2019 and 2018. Economic Injury Disaster Loans, EIDL, Economic Injury Disaster Loans, and the SBA Express Bridge Loans. Again, that's Express Bridge Loans. A key aspect for our agents is the Pandemic Unemployment Assistance, PUA, and you're going to hear a lot about that. Pandemic Unemployment Assistance, this really applies to independent contractors and people who may not otherwise qualify for unemployment insurance. We did get a letter, or it was published, the California Labor Secretary, Julie Sue, did publish something saying that this new system, because it's a whole new rollout at the state level, will be able to pay individuals within 24 to 48 hours of the application. But again, it's taken 2 weeks to create this new program and the technology. Those who get PUA also get the $600 per week additional payment added to employment uninsurance for weeks they are unemployed from March 29th until the end of July, but it does run through the end of the year. So go ahead and take a look at that, because they do have a deadline for that applying. Now at the local level, you've heard a lot about cities and counties enacting their own safer at home orders. Wanted to clarify for those in the Long Beach area and also LA too, effective through May 15th, 2020, so this year, May 15th, there's clarification and guidance for showing of listed residential properties. Open houses, as we well know, are forbidden. Showing should be done virtually whenever feasible. And those showings may include, those are essential, but they should not include tenant repairs, construction. In-person showings may only include 2 persons at a time, an agent and a buyer, or 2 buyers if those 2 individuals live together, such as spouses. Only those 2 are permitted. And you should also, the tenants or residents, sellers maybe should temporarily leave the unit while the house or the location is being shown, and all social distancing protocols must be maintained. It's important to know that the County of Los Angeles and the City of Long Beach, which has its own health department, all entities, essential businesses, even stores, real estate offices at their place of employment need to post social distancing protocol signage. Again, that social distancing protocol signage, there's a 3-page memo, or basically a template you can copy. It must be substantially in the form, and it must be posted at or near the entrance of the relevant facility, and shall be essentially viewable by the public and employees. A copy of the protocol must also be provided to each employee performing work, and agents should keep a copy with them when out in the field. So that's something to keep in mind. That's at least in effect and through May 15th, at which time we'll probably have more guidance as to which direction the governor and the local entities are going to go relative to the Safer at Home ordinance. I think that clarifies everything. We can answer questions later on. Thanks for your time. Appreciate it.
Thank you, Christine and Tim. We appreciate you guys so much. I want to give a huge shout out and appreciation just for some clarity on the government affairs team and what they just kind of read out to you guys about the City of Long Beach. As you know, the City of Long Beach kind of changed their rule last week, and it was very confusing. And so your government affairs team went right away and got involved with the City of Long Beach. And kudos to not only our team, but Assemblymember Patrick O'Donnell, who got involved as well in communication with the leaders of Long Beach and the Long Beach Health Department. Specifically, Phil Hawkins had an extensive conversations with the city attorney of Long Beach, city manager. And because of all of that, that is how we were able to release these very specific guidelines that allow us as realtors to still transact business in the City of Long Beach. So thank you to Phil and also John Giardinelli, who had a personal conversation with the city attorney. There's not many associations, guys, that are going to that level to fight for their members and our ability, really not our members, but also our communities, because we know there are people that still need to transact real estate. So I want to extend a huge thank you on behalf of all of our 13,000 members to our team for working so hard on that. So Now moving on to why y'all really probably came here, which is to hear from the attorneys. So I'm going to turn it over first to Mr. Ed Zorn, who again is the Vice President. Never mind. He's just really important at CRMLS. But one more thing before Ed gets started. John, I will unmute you when I need you to talk, so you don't have to click so many buttons at the same time, okay? So I got you on this side, John. You're welcome. Take it away, Ed.
Great, thanks, Barbara. I appreciate the opportunity to come in, and I've enjoyed actually coming and doing these events, you know, with the team here at PWR over the last few years. I enjoy having the opportunity to kind of take the stage with John, and it's always a fun time to take questions and interact with the guys, and I certainly miss, you know, seeing everybody personally, but I am, you know, pretty happy that we have such a large number that we can actually present to today on some of these issues. Kind of echoing some of Phil's comments earlier, CRMLS, actually about a year and a half ago, we had already put in place a kind of a disaster program. And so we also are fully operational. We were able to move all of our 100 employees to be working from home within about a 2-day period. So we have a fully staffed call center. Our trainings are still happening. So if you need some trainings at your broker office, something like that, you can give us a call. Those are still happening. Our full IT, all the developers, all of those aspects are still in place. And I know everyone's favorite department, compliance, is still up and running. And we're still fielding reports of inaccurate data and doing our best to making sure that the database is up and running and it's kind of best shape possible. So with that, what I'd like to do is kind of, you know, let's get started here and start talking about, you know, the clear cooperation policy. And I'm assuming, Barbara, everyone can see, you guys can see my screen here on the clear cooperation policy slide.
We can, Ed, you're good.
Perfect. All right. Yeah, when you're sitting at home and you're looking at your computer, you always wonder what everyone else gets to see. So we're going to talk about a little bit about clear cooperation policy and a little bit of the background of where this came from. This was approved by the National Association of Realtors Board of Directors in November. It actually has about a 2 to 3 year lifespan, actually. There is a group that makes recommendations at NAR called the Emerging Issues and Technology Advisory Board. They provide, and they meet very regularly. It's a group of about 25 brokers and agents, as well as, I think, 4 MLS executives from around the country. And for about the past 3 years, they've been getting inundated at every one of their meetings with questions and concerns about the off MLS activity, pocket listing activity, and specifically the concern with publicly marketed listings, right? These are listings that are showing up on websites. They're on Facebook, they're on Zillow, there's flyers, there's signs. There's nothing private about it. It's fully public, but not in the MLS. And in light of Article 3, which states that as realtors, we will cooperate with one another, this advisory board made the recommendation to move forward with what they call the clear cooperation policy to support Article 3 of the Code of Ethics by making it an MLS rule. And it's on the screen there. Within 1 business day of marketing a property to the public, the listing broker must submit the listing to the MLS for cooperation with other MLS participants. And that rule came out of this advisory board. It went to the NAR MLS committee where I was there personally. There was a good feisty, 2 hours of debate, and the rule passed overwhelmingly. It went into the NAR board of directors that approved the rule. Again, that's an 800-member board of all brokers and agents who approved this rule with a 92% approval rating. So the industry, it was very much behind this concept and this idea. They did implement a May 1st implementation date for MLSs that take this policy and make it a rule and roll it out into their systems. And that's what we're going to talk about here today. One of the things it's important to point out that this new policy relates only to residential vacant lots and residential 1 to 4 unit properties. It does not apply, and it's not required for commercial, lease, or a 5+ apartment building. Okay, so just to kind of clarify a little bit about the scope of who this policy applies to. So at CRMLS, we took this policy and took it to our 40-member rules committee and our 17-member board of directors, again, all being agents and brokers. And we basically turned this policy into a rule. And we'll talk a little bit about, what is marketing and how is that term defined. Inside of our rule, you'll notice that first sentence is almost exactly the same as the NAR policy, and we focus on, marketing or advertising a property to any member of the public. Our list of what marketing advertising includes it's a very broad list, and that was intentional from NAR. They want this definition to be very broad. One thing that we did add is that last sentence in our rule, and what we thought would be helpful for brokers and agents is to define very specifically what is a member of the public, okay? So under our rule, a member of the public is any individual that has not signed the agency disclosure form with the listing broker. Okay, that would be someone who's not a member of the public. The idea and the rationale behind that is you don't market and you don't advertise a listing to one of your existing clients or one of the buyers that you've been working with for a few months, right? That's not a member of the public. And so we decided in compliance that what we needed was something, a form, some kind of documentation that evidences this enhanced relationship between you as a listing broker and this buyer individual that you're already working with. And we thought the best way to do that would be to employ the already mandated and legally required agency disclosure form. And under California law, this is my lawyering part, the law says that you're required to provide the agency disclosure at the earliest opportunity available, or practicable is the phrase that's used, right? It's not, hey, right before you write up an offer, right? It's at the earliest point practicable. And so if you have an agency disclosure form signed with a person you've been working with, then it is permitted for you to show or talk about a new listing that you obtain before it enters the MLS, and it will not be considered marketing. That rule also goes to any agent whose license is hung under that brokerage firm. From a compliance standpoint, what we're going to follow is the licensing level, right? We're going to go to the Department of Real Estate, and we're going to see, is the agent that made this communication about a new listing that's not in the MLS, are they part of the same brokerage firm hung under the same license number as the listing agent, right? So that's kind of the category or the way that information will flow. So let's talk a little bit about what is marketing, right? What's included in this definition of marketing? And it's really any kind of communication about the property being available for sale. And that communication can be made in all kinds of different ways. So that's, a listing on Zillow or Realtor.com, a Facebook post, a tweet, some kind of posting on your own agent or broker website, right, is considered public marketing. An open house, certainly a showing or a sign, flyer, an individual email is that with someone who's not, your client, or you don't have one of these agency disclosure forms with, would be considered public marketing as well as a one-on-one conversation, right? So really, when you start thinking about what is marketing, we're talking about a very broad, definition as to what is marketing. And Barbara, as we move through here, feel free to cut me off with any relevant questions on a topic that I'm covering. I'll let you monitor that box.
Yeah, there has been a couple of questions, but I think it's best that I know what's in your presentation, so I think some of them will be answered as we go through. So I'm going to hold on.
Great. I do have a limited skill. As a lawyer, I can only focus on one thing at a time, so I'm going to focus on the presentation and let Barbara kind of watch over the questions, and she'll be timing those. So keep those questions coming on in, and we will have a couple of times during the presentation and right after to get some of those answers out. So as we start talking about what's changing, I've always thought the best way to start this is let's talk about what we do today, right? What happens right now today? And under our existing rules, right, you meet with a seller you did a great job, you got that listing contract signed. And within 2 business days of the effective date of that listing, right, you have 2 choices under existing rules. You're required under existing policy to deliver to the MLS the fact that you have this listing contract. And you can do it one of 2 ways. 96% of you, what you do is you enter the listing into the MLS in an active status. And I get that number because we track the other method, which is the exclusion form. Somewhere around 4 to 8% of our listings start off life excluded from the MLS, but 96% of all listings end up selling on the MLS. So you either put the listing in as active, or you submit an exclusion form by having your seller sign the CRMLS exclusion form or the CAR SELM form, and then you have to upload that to the crmls.org website, right? You have to fill a form out, it's 2 or 3 pages, you give us some information, and you have to then upload the form at our website to comply with this requirement. And realize only a listing that has had this process done is allowed to be excluded from the MLS under the current rules. So let's talk a little bit about what's changing. So you're going to do the same step 1. You're going to do a pitch for a seller. You're going to go to their house. You're going to do a great job, and you're going to get a listing contract signed. That's going to stay the same. 2A is also going to stay very similar, and that is within 2 business days, you're going to have to report to CRMLS that you have this listing contract. So you can still just within 2 days put it into active, just like you always have. So for those of you that don't engage in or utilize the exclusion process, frankly, nothing at all is changing. You do the same thing you've always done, get your listing, put it in as active. We are rolling out a new status called Coming Soon. So you will also be able to put it into our new Coming Soon status. And I'm going to go in my next slide over some details about Coming Soon. And that is a full status available for cooperation and compensation. The third mechanism you can do is really called registered, and it's just the same exact thing as the existing waiver or exclusion process. We're just bringing it, kind of updating the technology a little bit and letting you do that within the MLS platform. So you'll do that registration inside of Matrix or inside of Paragon as a way of registering, rather than having to go to the crmls.org website and doing that separate upload stage. So the way to think of a registered listing is it's simply replacing our existing waiver process, right? So not really anything new, just a different way of doing it. And then you'll notice one thing that's a little bit different is 2B. We are going to have this sliding within 1 business day of marketing the property. That property is going to have to get into either Coming Soon or active, right? So if you do any public marketing, Coming Soon or active is the status you're going to have to go into. You cannot keep it in registered at that point in time. It's got to go to Coming Soon or active. So a little conversation here about what happens if you have one of those SELM forms that says, I'm never going to put it in the MLS. My client never wants it publicly marketed. Realize under this new policy from NAR, the only way you're never going to put it in the MLS is if your client gives you the instruction that says, I don't want you as my listing agent or broker to publicly market the listing. What that means is the seller's telling you, I only want you, my listing broker, to share the listing with those agents that are part of your brokerage firm, hung under your broker license, and their clients, right? The people they're already working with, right? That would be the people you have that agency disclosure form with. You're not going to be allowed to put a sign up, to put it on a Facebook post, or to put it on your own website. Those things will not be allowed. You do any of those, it's got to go into the MLS. So if you have that, privacy concern where you don't want it to go public, you still have that opportunity to do that under the office exclusive process. So let's talk a little bit about the differences in statuses. And this is usually the slide that I spend the most time on. And I'd like to start all the way on the right, active, right? This is something you're all familiar with. Every one of you has probably put an active listing in, you know, probably in the last, hopefully sometime in the last month or so, you've used this status, right? And in the active status, right, all kinds of marketing are allowed. You can do anything to market the property. It's fully displayed in the inside of the MLS, meaning all of the other brokers and agents who are part of CRMLS can do a search and pull up your active listing. Obviously, you're aware there's a commission that's being offered, and all of the rules that Lori manages with regard to arbitrations and getting a commission come into play here because a commission is offered. Because all of these things are happening, including the ability to show the property, right? The days on market will count because you got an active listing and you're doing all kinds of marketing. You're opening the property up for people to come in and see, right? It's an active property. We need to be counting the days that it's active. There's also a full distribution out of the MLS. And what we mean by this distribution is, inside of CRMLS, we take your listing and we expose it not only to all the agents and brokers who are part of the MLS, but we also push it out of the MLS, where we send it to, right now, each listing goes to 22,000 individual agent and broker websites. We call that our IDX, the Internet Data Exchange, and that just, every active listing goes out to that. They also go out to our virtual office websites. In addition, I think the number right now is somewhere around 98.5 or 98.9% of you have authorized CRMLS through a broker choice to send your listings to Zillow. And so they go from the CRMLS, you know, to Zillow, goes to Realtor.com, goes to Homes.com, as well as to our List Hub syndication platform. List Hub is a place where, as the broker of the office, can go in, and they have over 100 separate internet advertising and syndication channels that the broker can choose whether to send those listings to or not. Again, 100% of broker choice, but it's another 100 locations that the listing you know, will go to. So that's the full distribution through the MLS, and that's the active status. So let's talk a little bit now about coming soon. You know, what's the same between coming soon and active? Well, a couple of things that are the same is, on a coming soon listing in that status, you can do all the marketing you want, just like active. You can have a sign, flyers, emails, right? You can put it on your website. You can put it on, if you're a premier agent and have access to the Zillow coming soon features, you can place it there, right? Flyers, anything you want to do from a marketing perspective, you can do. And it will also be displayed on the MLS. So this is a great new feature for agents to get access to those coming soon listings. And so you'll be able to do a search. You'll be able to send the listing from the MLS to your client through the email tools of the MLS. You'll be able to do a saved search for your client to let them come into the portal and take a look at that coming soon listing through the MLS features. Right? In addition to that, there is a commission that is going to be required, right? Just like a regular active listing, there is going to be an offer of cooperation and compensation. So let's talk a little bit about, though, where coming soon is different than active. Where the coming soon is going to be different is, number one, there will be no showings. No showings allowed under coming soon, not even by the listing brokerage firm. And if you think about coming soon, that makes a lot of sense, right? If you were able to do showings on a coming soon listing, why is it coming soon? Isn't that here now, right? If you can market it and you can show it, and it's got an offer of compensation, so you're saying I want an offer on it, why is it coming soon if you can show it? It wouldn't make any sense. So there are no showings on coming soon. Also, we have some limited distribution through the MLS. So while a coming soon listing is available to all the agents in the MLS, it is not going to go out of the MLS to these other websites. So it's not going to go out to the 22,000 IDX agent and broker websites. It's not going to go out of CRMLS and be sent to Zillow or Realtor.com or Homes.com. It's not going to leave the MLS and go to the List Hub platform for you to go to those other more than 100 syndication channels. The only distribution out of the MLS that's going to happen is when an agent using the tools in the MLS sends it to their own, buyer client that they have, or to a virtual office website, right? And just to give you a concept of scale, CRMLS has, as I said, 22,000 IDX websites that we service. We only have 22 virtual office websites. That's it. So that's a very limited group of brokers who are using that virtual office website. But because of antitrust rules and federal law, we are required to send that coming soon listing to the virtual office website. So that's what we do there. So because of this limited distribution, not being able to show it, we're also going to have a limitation of you can only be in coming soon for 21 days. Again, this is one of those kind of makes sense rules. It says coming soon, not coming next month, not coming next year, not coming whenever the heck I feel like it, right? It says coming soon. And so soon means sometime in the next 21 days. So that's why we have that 21-day limitation. But because of these limitations, we're not going to be counting the days on market while you're in this coming soon status, right? Because it is no showings, it has some of this limited distribution happening. We're going to differentiate that and not have days on market counting while you're in that coming soon status. So that's coming soon and active. So the moment within one business day of doing any kind of marketing, you need to get into one of these two statuses, coming soon or active. Now, on the screen, we still have the registered. Remember, registered is the replacement for the waiver exclusion process. You almost can call it registered/waiver, right? It's if you look at what's required for our registered status, what you're going to see is it's the exact same pieces of information that you need to put on the SCLM form or on the CRMLS exclusion form. We only need the address, we only need the list contract date, the price, the expiration date, and the day that you're planning on starting your public marketing, right? That's it. Those are the only things we need. It should take you about 2 to 3 minutes to register a listing. That's it. There is no public marketing allowed while you're in registered. Registered listings will not be seen by any other listing agents, no other listing brokers, no other brokers or agents in the MLS system will see registered at all. Think about it, right? Who sees your waived properties right now when you upload the waiver form to crmls.org? Who in the MLS gets to see it? Nobody, right? And it's the same rule for registered. Nobody's going to see it. The only people who can see a registered listing is the listing agent that input it, their broker or office manager, and us at the MLS staff. That's it. No one else gets to see it. Obviously, there's no commission offered, right? Because it's not in the MLS yet for cooperation. So there is no commission, no days on market are going to count. Obviously, you're doing no marketing, so no DOM's going to count. There's absolutely no distribution through the MLS. So it's not going anywhere. You cannot even send this registered listing to one of your clients or put it in a card or do a search against it. None of that is available. However, because of the concept of what we call a no cooperation listing, or some people refer to it as an office exclusive listing, right? This is that privacy issue where you maybe have a celebrity client, or you got a divorce situation with an order that says you have to be private on things. You are going to be able to show it, but it can only be shown to the listing broker's own client or the own buyers that are working with the agents inside that listing brokerage firm. That being, again, the people who signed that agency disclosure form, right? So that's kind of how that registered is going to work. Again, just the new way of doing a waiver or an exclusion. So we ready for questions yet while we're here, or do we want to?
You know, Ed, I think that I know what's in the rest of your presentation, and it's not necessarily repetitive, but I know that the questions that are being asked are so detailed that we might just want to go to those questions now, because I think the rest of your presentation is more just the wording that you're going to cover through these questions anyways. Does that sound good?
It does, actually, and that's why I would definitely suggest here. Normally, when I do these webinars, I try to take an entire hour. I'm trying to make this one a little short because I know John is getting edgy there to want to talk soon. I'm not exactly sure if I've seen John be muted for almost an hour in my life, but it's we'll see what happens. So this is a slide that most people like to keep on the screen as we ask questions. So let's go ahead and let's hit it.
Perfect. So the first question is, does the clear cooperation policy include properties listed for lease?
No, it does not include properties for lease. So none of these, this mandated rule of having to put a listing into the MLS for cooperation applies. It does not apply to leases. It does not apply to commercial property. It does not apply to units above 5, only to residential properties, you know, for sale properties.
A couple of questions have come in about if you have a signed buyer broker agreement, can you use that if you don't have the agency disclosure signed?
Certainly, right? And in other words, I would hazard to guess that if you have a buyer broker representation agreement signed, it has already been practicable for you to do your agency disclosure. So as a risk management tool, I would strongly recommend that you probably, under state law, you probably already should have the AD form signed before you sign a buyer broker agreement, or at least at the same time. But certainly, if you have a buyer broker agreement that evidences an actual client relationship in writing, that's actually even better than the AD form. And I would, from a risk management standpoint, I would strongly recommend you have a buyer broker agreement signed before you show a person a property that's not in the MLS. There's quite a few risk management benefits of that buyer broker representation agreement that really give you a ton of protections that you'd want to avail yourselves to, more so than what there's no protections with the agency disclosure form. None. It's just a disclosure. That's a challenge.
I've unmuted John because I know he wants to say something on this, and this is something him and I have had deep conversations about. And you mentioned it, Ed, about how the statute already reads that the agency disclosure should be signed as soon as possible. And so, John, can you jump in there on the buyer broker versus the agency disclosure?
Yeah, first of all, I want to congratulate Ed and his team for the incredible job they've done with a very, very difficult task that they had in a very short period of time. And I don't think I've made it any kind of a secret that if it were up to me as a defense lawyer who represents real estate agents and brokers almost exclusively, I would prefer that the buyer broker representation form be made mandatory in all cases. I believe there's support for that in Article 9 of the Code of Ethics, which says that all agreements, including but not limited to, et cetera, and then they add representation agreements, gives great credence to that. I agree 100% with Ed that as a risk management tool, particularly in light of the jury instructions that are being used, and in light of a case called Field versus Century 21, that the buyer broker representation form should be used. And if I were the king of the world, it would be mandatory that it be used in all transactions. I know that Ed had made that proposal to his board of directors, and unfortunately, in my opinion, not putting Ed on the spot, but because I know he has to work for a board like I do, but in my opinion, they should have let it alone and should have left it at least the way Ed had originally proposed it. I just think that form should be mandatory.
Thank you, John. All right, Ed, some other questions have popped up, and there's 5 or 6 of them, and I know what they're all trying to say. They want to know if it's considered marketing to just email it to your sphere of influence because they've done business with them in the past. And I know that I have a huge sphere, and it would be a violation of the rule if I just emailed it to my sphere of influence or my mailing list. So can you give clarity on that?
Yes, and yes, you're breaking the rule. So the rule is super clear. Do you have an agency disclosure form signed with that individual human being within the last year? So I want all of you right now, right? We've got 600 plus on the, on the line. Think about how many email addresses you have in your contact list right now. How many have you got in the last year? How many contacts do you have in there? You got that number? How many agency disclosure forms do you have signed? Right? There's a difference between those two. You can send it to the people with whom you've got an agency disclosure sign, right? What that demonstrates is the concept that the relationship between this person in your sphere of influence, by signing an agency disclosure form, demonstrates that you've taken a step beyond just that sphere of influence. So they're no longer just a member of the public, right? They're not just somebody who happened to go into one of your open houses 5 months ago and dropped an email address on a list, right? They've taken an affirmative step voluntarily by signing that form to say, yes, I acknowledge that you have given me this disclosure about how agency works, which means you've stepped beyond just, here's a human being who happens to have an email address, which we all know you can just buy off the internet, right? So we need more than that. If all you have is somebody's internet, email address, they're just a member of the public. They just happen to be a member of public that you got the email address for. That doesn't mean you have any kind of, agency type level of relationship with them.
Perfect. And someone's asking about where do they upload a SELM. I'm assuming this person's wondering for the SELMs after May 1st, because I think everyone knows where we upload them right now. But after May 1st, registering, correct me if I'm wrong, is basically effectively replacing uploading a SELM. It
is. So let's talk a little bit about registered and timing. And for this, I am going to go to one of my other slides real quick. And that's this one here. So the rule has to be implemented. The rule comes to life, if you will, on May 1st. May 1st is a Friday. In the MLS world, we never roll anything out on a Friday because we want to be available with our full call center and everything available to be able to support any of these new rules. So we're starting our enforcement on May 4th. And so that's when this coming soon status will be available, will be on May 4th, all right? Now the registered status, because we're putting all of our technical chops and resources into rolling the coming soon out, the registered status isn't going to come out until the summer sometime, probably mid-summer 2020. And so until then, you're going to do the exact same thing you're doing now, which is get an SCLM form signed, upload it to the crmls.org website under the excluded listings page, and you're going to upload the form. Once we get to where we have the registered status open and available inside the MLS, here's the great news. You still have to go get the form signed, but you don't have to upload it anywhere. We're not going to require the uploading of the form, just that you do the registration process in Matrix or inside of Paragon. And then if we get a report or we have a concern or we decide to do some investigation in the compliance department, then we're going to ask you for a copy of that form. So we basically designed this, registration process as an opportunity to enhance the workflow, right? Try to kind of get rid of some of these steps you have to do and make it a little bit easier for you in the work you have to do as an agent by using this registered status to replace the waiver and exclusion process.
Perfect. I'm trying to go kind of in order of the theme of the questions because there's a ton of them, which is why we're doing this. But let's move into the difference really between registered and coming soon. There's a lot of questions about, can I put a sign in the yard while it's registered? And of course that would be marketing. So that would be a need to be coming soon. So can you really clarify the difference between registered and marketing?
Yes. So the question really here is whether you can do what is marketing, right? It's on the screen. I can't make it any clearer. Registered means no marketing. Coming soon is you can do all marketing, right? That's the answer. Now, you can give me 5,000 what if questions. The answer is still going to be no marketing on registered and yes on coming soon. That's the answer.
And then the last question with regards to registered is people are not understanding how there's no commission offered with registered, but how you can still sell a home under registered.
Yeah, I get this question a lot. So think about it this way. Registered is simply replacing a property that's not on the MLS, right? It's replacing the waiver and exclusion process, which is someone who's saying, I entered into a listing contract, but I'm not putting it in the MLS. So let me ask you this question. How much of a commission are you guaranteed on a property that's not on the MLS? It's the same answer for registered, right?
Yeah.
There is no commission, because there's also a situation where if you're not an agent in the listing brokerage firm, right? So I'm a broker in California, right? Barbara, you're a broker and agent in a different area. If I took a listing, Barbara better not know about my listing. She better not know about it. Because if Barbara knows about it, some level of marketing went on. So how is Barb supposed to be inquiring about my listing and about a commission when she shouldn't even know it exists?
Exactly. And I think where the confusion, I'll use a real life example, because I think that's what the confusion's happening is, if I have a property that's registered in the MLS and I have the listing agreement and I have a client that I have an agency disclosure with who wants to buy it, I can show it to that client because they are a client of my brokerage. And if they want to buy the property, the reason commission isn't offered is because the commission lands with me, the broker, internally between the contract of the seller and the broker. So I hope that clarifies it for, being boots on the ground, guys. I know what you're living in. And I think that's where the confusion is lying. You're like, well, am I not going to get paid? Well, of course you're going to get paid. You have a contract with the seller. That's how you're going to get paid.
Right, so that no commission offer that's referenced there is no commission offered to a cooperating broker, right? A no commission to a different broker other than obviously what agreement like Barb just described very eloquently, right? The listing broker is obviously going to get paid, but it's no commission to any other brokerage firm.
Exactly. So moving on to coming soon, lots of frustration and questions on coming soon only being allowed for 21 days. And what if my seller isn't ready? And what if the painting isn't done? And what if the tree isn't removed? I've got about 20 different examples in here. We're not going to bore you with each one of them. But what happens at the end of those 21 days when I want to extend it?
You're not going to extend it. It's going to go to active. So that's going to be your job as a broker to figure that out, right? Coming soon is coming soon, not eventually. And so there was a lot of debate. We did actually a survey across the country to determine what are the dates that people use for coming soon. The vast majority of MLSs that have a coming soon status across the country have it either at 14 to 21 days. There were a tiny handful that had 30. But almost all of them were they were about evenly split between 14 and 21. And our board of directors decided 21 days still stays within the concept of soon. So what I'm going to suggest to you is if you have a bigger project going on, right? And trust me, I get this. I used to represent a lot of investors. I was an REO broker. I dealt with contracts, dealing with listings. Honestly, I've never had a contract be done the day they said, ever in my entire life. So I understand that problem. It's up to you as the listing broker to decide when's the proper time to transition into starting that coming soon listing and starting your marketing. This is a good example of another way that you can use register. So let's say I've got a 60-day construction project coming up as part of what needs to happen to get this property ready. What I'm going to do is I'm going to put that property, I'm going to take that listing agreement to kind of lock the deal down, and then I'm going to put it in that registered status. And there's going to be no sign, no marketing, nothing's going to happen with the listing. and it's going to sit and registered until we get closer. And then at some point, when I talk to the contractor and things are going, and I'm confident that I'm going to get done and ready to go with all of my marketing sometime in the next 21 days, that's when I'm going to transfer it from registered to coming soon. And that's my call then as the listing agent to make that call. So you're going to have to plan for that, understanding that that 21 days will not get extended.
Can you please also clarify that in coming soon status, it will not go to any of the portals, and portals won't be able to have a VOW website?
So let's talk a little bit about what these terms mean. So the rule is not that it can't show up on a portal. The rule is that CRMLS will not distribute it to a portal, right? Same thing, CRMLS will not send the listing out to the Internet Data Exchange feed, right? So it's not going to show up on these 22,000 websites. That's not the same thing as saying you can't employ your own technology person to put a coming soon listing up on your own website, right? That's permitted. That's you doing marketing yourself, right? And there is a situation here where if you're as an example, some kind of premier agent with Zillow as an example, and you have access to a coming soon portal as part of the services that you pay for with any kind of real estate portal, you can certainly put your own listing anywhere you want, right? What's going to happen though is it's not going to come through the CRMLS data feed. That's the distinction. With regard to the virtual office website, remember what a virtual office website is. It is basically a broker who is performing full real estate services on the web. So let's use this. The best way to do this as an example is under the current federal antitrust laws. As an MLS, we're under legal requirement to make sure that we allow for a brokerage firm that is operating entirely online, in essence, doesn't have a physical office for someone to walk into, that they have and are operating under the exact same rules that our brick and mortar office is working under, right? So if you're working in a regular office, and we're past this COVID-19 time period, and a client can walk into your office and you can, print out a coming soon flyer or send them an email about a coming soon listing in the MLS. We have to make that opportunity available for those who run a virtual office website. Now, in running a virtual office website, what we mean as far as sending coming soon listings to a VOW is it's going to have to be behind the password protected area of the website. It's not going to be allowed to be on their public display. They're going to only be able to show that coming soon listing to someone that they have an agency relationship with, right? And has a password to get behind the VOW wall.
Can you also talk a little bit about how properties can be sold under a coming soon status? There's a lot of questions about how to possibly do that.
Sure. And for those of you who have represented landlords before, with maybe not the most friendly of tenants, we've done this many times. And frankly, I've also done this myself. Many of you know I live in Knoxville, Tennessee. I moved here about 2 years ago. And so I've actually bought in the last 2 years 2 homes sight unseen. So that's how coming soon can work. You're not going to be able to show it, but you can certainly make an offer on behalf of your buyer that you're representing on it. And we're learning a lot about that right now with COVID-19, right? Look at all of the opportunities you have to do virtual tours and some of these really cool technologies where you can actually walk through the property on your computer, right? Using a virtual tour program or Matterport, where they give you that floor plan and you can kind of pick the next dot to go look at, and the 360 views, right? We actually put offers in on properties here in Tennessee without ever seeing them. And then we got deep into escrow, and I mean through appraisal, through inspections being signed off before we got on a plane and flew out to confirm we would actually close on the deal. So it is definitely possible, you know, to put an offer in on a property without having actually physically been inside of it. And you can do that while it's on a coming soon status.
And another question, it's been asked a couple times, and I know I sat in the room and when this was voted on at National Association of Realtors, and it's talking about the celebrity clients and how come I can't just tell another agent who has the buyer for that listing. And really the explanation that was given on the floor, and I hope it's helpful for our members to hear, is that if you sit in a listing appointment and you tell the seller, I can sell this myself, then you're going to have to prove you can sell it yourself.
Yep.
You're going to have to prove you actually have the clients, not, well, I'm going to call up my good friend Stephanie over at Century 21 in Fullerton, and I'm going to tell her about the property, but I'm not going to tell anyone else. And so people say that for celebrities, that's how it should work. But the reality is, if you truly have the client, then you have the client. And if not, then it should go on the open MLS. So Ed, can you be specific about the celebrity client issue? Apparently a lot of our members have some celebrity clients, which I'm a little jealous.
Fantastic. Congratulations. Yeah. I think the way you expressed it is an excellent way. I've had a little bit of experience this myself. I dealt with a property of a California Angel in the year they won the World Series, and he was an MVP. And everything, frankly, was run through his mommy's trust with a lawyer in South Carolina, right? So I understand these can get complicated and these things matter. But I think, Barbara, the way you described it is an excellent scenario, right? If Stephanie from Century 21 is allowed to know about this property, well, then why can't all the other agents in the MLS know about this property, right? What's so special about Stephanie? Because she's your buddy? So only she gets to know. Either you got a buyer, or you're able to have out of your existing client pool or future client pool have a buyer for this property, or you don't. But if you're going to publicly market it, which is the conversation between you and Stephanie, right? That's you marketing to Stephanie at Century 21 in Fullerton that you have this property. Well, why can I, Ed Zorn, with my office in Corona, also not be aware of this property? Maybe I have a buyer for that property too. And it goes to what John had identified too under the Code of Ethics, right? You know, under these articles of the Code of Ethics, especially Article 3, right, is Article 3 says you will cooperate with one another. That's what it says. So either you're going to cooperate or you're not. And so if you're going to cooperate with Stephanie, then you got to cooperate with me, Ed, as well.
Yeah. And then lastly about coming soon, and guys, we have a ton of questions here, and we do have to move on to John eventually because he's got a ton of great information. And then what I'm going to do at the end is any of the lingering questions we will try to address if we have time. But I do want to get to the very specific one that's been asked. Well, a real quick one. Who all will be able to see the coming soon listings? Will just office management, brokers, obviously
everybody,
or is it just anyone who has an MLS access?
Coming soon is available to anybody, right? So you can do a search on it. It's just like an active listing or a sold or a pending, right? It's going to be a coming soon. And so everybody can see it. You can send it, you know, out through an email to a client, right? You can do a saved search for coming soon. Okay. And your client will get a new coming soon listing in their inbox, right? So it has all the same functionality as active.
Perfect, except for the portal. It will not be out on the portal.
Correct. It's not going to leave to be distributed by CRMLS to some of these other syndication channels.
Perfect. And then last question on coming soon is lots of people are talking about what if I want to put it from coming soon back to registered, which I know you cannot do.
Not going to happen.
Yep.
You're not going to be able to do that.
The second question is agents want to show their own coming soons.
No. And for that, let's go to the new rule 9.3. And you see in red is the new wording, right? For any property in which listing broker selected a status of coming soon or hold, listing broker represents the property shall have no showings or tours by listing broker or otherwise. So here's the rule on coming soon, guys. If you're coming soon advertising or marketing results in someone really hot, really wants to get in there and see it so they can make an offer, you need to put it to active before you walk through that door. Not after, not a day later. Before you walk over that threshold, that better be an active listing. That's the standard. If you walk in and it's in coming soon and you put it active an hour later and we find out about it, we're going to hit you with the violation. Right? It's got to be active if someone walks in the front.
Absolutely. So if I want to show the property tomorrow to a buyer that called off the internet, then I'm going to put it active tonight and I'm going to show it tomorrow morning. Now,
Correct.
One question that I know frustrates members across the board, and I do want to hear your answer on this personally, is now that we have the coming soon status, this should eliminate the no showings until 10 days from now after the open house. I see Lori nodding her head because like a phone call Lori gets all the time. So what are we going to do about that when it has been in coming soon and then it goes active and then the agent still puts in the private remarks that there's absolutely no showings for 10 days until the open house?
So, okay, so a couple of things. That's a rule issue. So right now, as it sits today, the CRMLS definition of active does not require that the property be available to show. So that rule would need to be changed to accommodate the challenge that you're talking about. And I can tell you that was a proposed rule change that came through the Rules Committee about 9 months ago, and it did not go through. However, that was before the coming soon issue. So it would not surprise me if after we roll out coming soon, that the Rules Committee and that CRMLS maybe revisits that issue as to whether or not having a property being available to show, as long as it's not a tenant issue. There's always going to have to be this exception for, you know, a tenant who has lease rights or some kind of limitation, you know, available. And I can tell you, many MLSs across the country have that as a requirement. I can tell you, I'm a broker here in Knoxville, Tennessee, and that is absolutely a requirement here in Tennessee, in my local MLS. You must be able to let someone in the front door of that property or you cannot be inactive.
Yeah. Okay, coming soon, everyone's saying, multiple people are mentioning that agents are just going to go from coming soon to hold.
Remember, you know, again, while that would be theoretically possible, that also means the agent is not going to be showing the property at all, right? And hold also still requires a specific instruction, you know, from your seller. One other thing to say about coming soon, you know, as we get into the actual rule for coming soon that's worth mentioning, is coming soon is also going to require a form, right? There's a informed consent, if you will, to put your property in coming soon. And it's going to explain and lay out for your client all of these limitations about the lack of marketing, the lack of distribution, that it's not going to go to these 22,000 websites, right? So there is going to be, you know, and the fact that there can be absolutely no showings of the property. So your clients are going to have to agree to a bunch of these limitations, and same thing with hold.
Yeah. Last two questions. Does coming soon require photos?
Yes. The coming soon, the required fields for coming soon are exactly the same as active. It is a full listing with photos and all of the other required fields being in the MLS.
Perfect. And last question is, how is it going to be policed?
Okay, so this is an important, really, if you will, foundational kind of rule, because it really goes to the heart of what an MLS is as far as cooperation. And so as a result, the fine for violating these policies, including the no showing policy, the mandatory submission, is going to be 1% of the list price. That's going to be the fine. It's going to be at least $500, but it's going to be 1%, but not more than $2,500, right? This is a very serious issue. I can tell you, around the country, there are a number of MLSs where even the first violation of this is $5,000. I know of one MLS that if you violate it 3 times, they permanently terminate you from the MLS, right? So our fine structure is a little bit lighter than others around the country. And especially at the beginning, keep in mind too, we are going to be issuing warnings, right? Our goal here at CRMLS is not to collect money from fines. It's to get you to comply with the rules and to get that listing that you're publicly marketing into the MLS for cooperation with the other buyer representatives. So we will be issuing warnings. If you get a warning, you have 1 business day to get that property into the MLS. And if you don't, then we're going to hit you with a 1% of the list price.
Perfect. Okay, Ed, I'm going to have you stop sharing your screen right now.
Okay.
Thank you so much for all of your questions and answers. And there is actually a lot more, but some of them are very transparent with, I know, some things that John's going to talk about, and I want to hear John's input on some things. And John, can you just also stress the information that you know from the California Realtors about the PUA and that we need to wait for the California EDD to get their site up, and realtors should not be applying for normal unemployment?
Yeah, I'm not an employment attorney, but in talking to the attorneys in our firm, the system's crashing because of so many applications. And so I had the same experience applying for the SBA loan with another business that I own. You just have to be patient. You have to keep trying. But for right now, as far as I know, I don't believe the system is up and operational. There's an attorney in our office that's been assigned the task. His name is Nathan Klein, and he's been working on that almost exclusively. So for those that are Pacific West members, you can go into our website. All of the articles that we're writing on any subject, including the one Barbara just mentioned, are being posted right now. And of course, they're all free. And so just go to the Tyler Bursch website. So did you want me to get started, Barbara, on a couple of things? First of all, I'm really grateful to Ed especially, but to everybody. When we set this up originally, Lori and I, it was with the understanding that 2 weeks from now, we're going to be having these new rules coming down from CRMLS. And so we wanted to give Ed as much time as he needed because this is such an important topic. It's one of the two probably more dominant topics that are coming out right now. Real quickly, we're going to be recording this. I believe Phil is recording it. And so I want to make it clear to everybody that all of the conversation and all of the opinions that are being stated are just that. There are opinions. We're going to be spending a lot of time over the next year deciding in retrospect what the standard of care should have been. And so what I want to make sure, particularly if there's any plaintiffs' lawyers listening, is that what we're talking about right now are aspirational, particularly the things I'm going to be talking about. And so don't be suing people for standard of care issues and relying on what I say, because we're going to be talking to the A students right now, not necessarily the C students, which is where the standard of care is. Couple of things. First of all, I want to remind everybody that while it's true, and Tim and Christine have been pointing out and been doing a great job, that real estate is an essential service, and that includes a lot of aspects of real estate. That doesn't mean it's business as usual. And so one of the things I want to warn everybody about is pretty clear based on the conversations we've been having with the government affairs directors and also with some of the politicians, is that business as usual it does apply to real estate, but it's something that can be taken away from you as well. And so for those of you that are, I was listening to some of the questions, and the sense I got was, how can we circumvent the issues? How can we circumvent the rules? And I don't mean to offend anybody, but frankly, if that's where you're at right now, trying to figure out how can I get around this stuff, you're going to make it bad for everybody else. And so I'm going to talk about the standard of behavior a little bit, touch on some of the things Lori said. Pretty clearly, open houses are to be virtual. There are no physical open houses pretty much anywhere. Some of the cities have specifically banned them, but particularly the governor's order makes it pretty clear. So let's talk about some things that you can do to make yourself aware. Number one is stay attuned to both the Pacific West website and to the CAR website, because both organizations, in my opinion, are doing phenomenal jobs. CAR is posted, and most of you by now, hopefully, have become clearly aware of the best practices. I know that Ed and I have had conversations over the years when somebody gets sued, they get sued for what's called negligence. And negligence contains 4 elements, the first of which is your duty. And right now, it's not clear what your duty is. I believe, based on what I've been talking to the attorneys at the NAR level, is that we have more responsibility as realtors today than we've ever had before, because people are looking to you for guidance on issues that no one has ever faced before. And so I believe, while it certainly isn't clear, you're going to need to be really, really careful and really, really cooperative. Ed mentioned cooperation a bunch of times, and I think that Article 3 is going to be more important than ever. CAR's come up with 6 forms so far. I'm going to go over them really, really briefly, because I know there are a lot more questions for Ed and the others, and maybe even 1 or 2 for me. But I think that CAR has done a magnificent job on some of the forms that they've come up with. Now, I want to make sure you understand that 4 of those 6 forms are going to be revised. I'm not sure if they've come out yet. I'm not a realtor, so I don't know, but I know they're going to be revised within the next day or 2. That would be the Coronavirus Property Entry and Advisory Declaration, which is probably the most controversial of the forms, because it's a declaration that everyone who's entering property is being asked to sign. It is being revised, and there will be a webinar on all these forms on Friday at 10 o'clock. Go to the CAR site to register. That form, specifically, I've had some conversations with the CREIA people, the inspection people, and they're not necessarily saying we won't sign it. What they're saying, however, is that you should send it to your inspector before he or she comes out to the property, specifically so that they can review it ahead of time, and you'll know ahead of time whether they're willing to sign it. And again, there will be some revisions to that. Another form, which I think is an excellent form, whether you have a listing prior to the COVID shutdown or whether you're taking them now, and that's the listing agreement addendum, the coronavirus addendum, also being revised. The reason I like this form is it's a great form so that you can sit down with your clients and have an adult conversation about the kinds of things that have come up since the shutdown, whether they agree to add it to your listing agreement or not. Go over the issues contained in it and talk to them about the things so that it's clear what your instructions are, so that you can make sure that your instructions are not violative of the law, of the Code of Ethics, or of the MLS rules. Another form, again, that's being revised this week is the Notice of Unforeseen Circumstances form. I think this form is such a common sense form that it goes without saying that it ought to be used, because frankly, we're seeing, I think all of us that are doing this as a business right now are trying to keep you guys abreast of what's going on, are seeing unforeseen circumstances on a daily basis that we hadn't thought about yesterday. Things are coming up today. And so just be aware of that. The coronavirus addendum is being revised again, and that form is a form that can be attached to your agreement. Again, you got to be reasonable with your agreements. We don't know what the courts are going to do with ongoing transactions, whether they're going to determine, for example, that, look, no one anticipated this. We're going to look at some theories that Ed and I haven't looked at since law school: impossibility of performance, force majeure, impracticability of performance. Because clearly, if you entered into a contract before all this took place, you did not foresee or think through what circumstances would be coming up during your transaction. So therefore, there's a solid argument. You never really had a meeting of the minds because things changed dramatically after all of this took place. So again, more important in my mind than ever, and I don't know if Lori agrees with me or if Ed agrees with me, but in my mind, more important than ever that you cooperate for the benefit of your client. I think that Article 1 is going to become an issue down the line. For those of you that decided it's not your client that should be first, it's you, and Article 3. I think those issues are going to be very, very important. Another couple of forms that I really think CAR did a bang up job on, particularly this coronavirus rent payment delay and repayment. I've done a little survey of the boards that I represent, and the sense that I get is that at least for April, while delinquencies did go up a little bit, we aren't seeing the incredible spiking that we thought we might see. Now, whether that'll change come May, we don't know for sure, but at least in Orange County and in Long Beach and in Southwest Riverside County, particularly, we're not seeing the level of spiking that we thought we might see. So that's actually pretty good news. So that takes care of the forms. Like I said, there'll be 3 new forms coming out this week as well. Those 3 new forms will all be landlord-tenant forms, and they will be the version of the current purchase transaction forms. So they're going to be coming up with some unforeseen circumstance forms and some other of the same kind of forms we're already talking about, but on the landlord-tenant side, because, and I know Barbara and I have had many conversations about this as well with Phil, that frankly, we're seeing about half and half landlord-tenant questions and transactional questions. We're seeing just a tremendous amount of landlord-tenant questions. Some good news for those of you that were concerned about learning too much. The RPA, which was being significantly revised and was going to be coming out on December of 20, has now been postponed for a full year. So for those of you that have been keeping track of the new 16-page contract, which has been completely revised in terms of the way it looks, don't worry about it. We'll be teaching on the old-fashioned current RPA, and of course, the post-COVID issues that will be coming up in droves, I suspect, after this is all said and done. Another thing on forms that I'd like to just point out real quickly is, look, guys, don't play games. I don't know how else to say it. Don't play games. I've seen a lot of offices come up with their own forms. That is actually a national trend. I believe, Ed, I know that myself are members of an NAR attorney discussion group, and the attorney for the National Association of Realtors and many other attorneys, including myself, don't really believe that these hold harmless agreements are going to carry a lot of water down the road. I think that while it's great that you try to protect yourself and maybe even your client, the reality is that hold harmless from what? We still don't know what kind of illnesses, what kind of issues are going to crop up. So while people may be wanting to use them, and I'm not saying you can't, be very careful about signing them, and be very careful about thinking that they're really going to cover you, because in reality they may not. Professional standards, Lori mentioned, and I'm not going to duplicate what she said. She and I are going to be speaking tomorrow, and we'll probably put something out. But the National Association of Realtors has made it pretty clear that if you don't do the things that are required of you based on whatever your local and or state executive orders are, or you decide to play games, you're going to be looking at some very serious ethical issues. And of course, if you have ethical problems, which means you fell below your expected behavior, you're probably going to have some civil damage problems as well. So NAR has put together some issues, as Lori mentioned, Articles 1, 2, 3, and the like are going to be all important. We're going to probably push out an article that Lori and I will talk about tomorrow, and then how we can deal with those. Also keep in mind, and I know this is something a lot of people don't talk about, but when you signed on to become a member, you agreed to abide by the association's obligations imposed by the bylaws. In other words, you have certain member duties. The most common in the past has been you don't come in and harass staff, you don't come in and sexually abuse or harass staff or other members. But there's also a number of member duties dealing with things like complying with law, complying with local ordinance, complying with sign ordinance, for example. And I believe, and NAR believes, that a lot of associations are going to push out member duty issues. So just, I guess, for those of us that are religious, and for those of you that just follow the old-fashioned golden rule, just use common sense. Treat other people the way you would hope to be treated. And this is a great opportunity, I believe, for organized real estate to really get back up to where it ought to be in terms of the eyes of the public. If you behave yourselves properly, if you put your clients first, cooperate with each other, I think you're going to be better off. A couple of other things on professional standard. Valerie already talked about the DRE. Although most hearings at Pacific West are being postponed, there are still ways that things can be resolved. Christine mentioned the Long Beach ordinance, so I'm not going to touch on that. A newsletter went out today. I believe that what happened in Long Beach is a good model for what ought to be done everywhere. Virtual showings wherever possible. If you can't do a showing virtually, then really comply with the distancing and with other protocols. In Long Beach, they made it pretty clear that only 2 people, not 3, can go into a house. In many jurisdictions, you can go in with your client. But in Long Beach, they made it clear that if 2 people are going to go in and one of them is not the agent, they have to be living together on the day and prior to the showing. In other words, they had to be quarantined together, and then they can go in together. So it's going to be mostly spouses going in with each other. As far as inspections and things like that, follow distancing protocols. If you're the listing agent, make sure you go in, open everything up, get everything ready to go. Tell your sellers to leave, maintain their social distancing protocols, and so forth. Landlord-tenant, look, kids, you're not going to be doing evictions if you're in Los Angeles County probably till August or September. So it behooves you to sit down with your sellers. Number one, if you're going to, with your tenants, excuse me, number one, if you got to show the property for some reason, make appointments ahead of time. Don't just assume that the tenant's going to let your people in because you think they have to. So be cooperative with your tenants. Treat them properly. Try to work out showings and other types of appointments. If it has to do with a repair, be careful that the repairs should be for things that are, quote, health and safety oriented. So if there's piping issues and things like that, try to work it out. If you're worrying about payment, try to work it out ahead of time. That's why that form is so valuable. Because again, while they may not have justification for not paying you, the fact is most people are not doing that. But if they do not pay you, there's nothing you're going to be able to do about it for quite a long time because you can't evict them. So you can do whatever you need to do, but you're not going to be able to issue subpoenas. You're not going to be able to get the kick-out orders and all of those things probably for quite a long time. And if you're in places like Los Angeles County and other places that have adopted fairly stringent rent control ordinances ahead of time, you're probably going to be seeing payback ordinances. Whether these ordinances will be constitutional or not, I know Ed and I probably believe there's just going to be an awful lot of constitutional stuff. Frankly, this whole thing is a constitutional question, but we're not going to get into that today. Liability. We're already seeing lawsuits. Now, some of you probably already know Walmart's been sued for wrongful death, and we're seeing lawsuits being filed on all kinds of constitutional issues. A lot of churches are filing lawsuits. And so we believe that this is going to be a pandemic, if you will, for the courts. They're going to have to deal with a glut of lawsuits. They're already dealing with the fact that whatever was scheduled between now and probably July is being pushed into and is now sitting on top of all of the other things that were scheduled for July. But we're going to be seeing a lot of lawsuits. So again, we're not real clear on what the standard of care is right now. So just be really cautious. And if you're really not clear on your expected behavior, reread the code of ethics. Reread them. Reread the rules that Ed's posted and that Phil's posted regarding MLS. understand your obligations very, very clearly, because we don't know what the damages are going to be. We don't know, for example, if you allow somebody into a house knowingly aware that they have some type of symptom or that they've been exposed. We don't know what those issues are going to be. We don't know what the damages are going to be. So just be aware of that. And then in closing, I'm not going to touch on, but what we're seeing is, so be very careful of, I think Lori mentioned a couple of SBA scams. We're seeing a lot more scams right now. Whenever there's $2 trillion being thrown on the table, there's going to be scams. Remember, the IRS never calls you. The IRS only responds and only contacts you in very limited ways. So if you're getting an email or a phone call from the IRS, you're not getting an email or a phone call from the IRS. So be careful of scams. Be careful of cybersecurity. Be careful of cybersecurity issues. I know that I've been talking to a lot of people about those kinds of issues, again, because the scam artists are out there in droves. Be careful of Americans with disability issues. Talk to your IT people and make sure your websites are compliant. I just got off the phone with a lawyer that's, unfortunately for him, what we would call a bottom feeder, but he's a pretty decent guy. He gave me a lot of good information about what the lawyers who are suing people that are, for example, partially blind or totally blind, are suing for website violations, particularly at a time when we're all working remotely, and those kinds of issues have become more important. And then lastly, and then I'll open it up for questions, be careful of fair housing issues. I don't remember if it was Barbara or somebody brought to my attention that some landlords were refusing to rent to first responders because they were concerned about how the exposure that people that are frankly keeping us healthy and alive are being exposed. And so there's those kinds of issues. People aren't showing houses to people that are from certain countries because of fear of being exposed. And so we're seeing, again, things, frankly, I don't know. I know Ed and I have been doing this for a while. Both of us have been very blessed to have an incredible career, but we're seeing things that we haven't seen before, things that haven't, frankly, come up since 1917 when we had our last major pandemic. So we're trying to give you the best advice we can. From my standpoint, I've taken the position I'm going to give the most conservative advice that I can give, tailing on to what Ed said before, the best risk management advice, because we don't know what's going to happen. We don't know what the insurance companies are going to do with a lot of this, these kinds of issues that are going to come up. We do know that if your conduct is intentional, they're probably going to deny coverage. So be very, very careful about that. And with that, Madam Moderator, I will shut my mouth, which you all know is very hard for me to do. Allow myself to be muted, and if there's any questions for me, I'll be happy to try and answer them.
You are muted, and if Ed, if you can unmute your line, because we're going to have lots of questions for both of you. I'm going to start though with Christine. I know you were taking some notes. I'll unmute you. I got you. I'll unmute you. I know you guys had some questions, or you were taking notes on a lot of the questions that were coming through about the unemployment, and do you want to wrap up any of those quickly? Because we had a ton of questions about that.
Sure. And you can try to catch me if I miss any. I know my trusty assistant went to touch up his makeup. So edd.ca.gov, edd.ca.gov is where you're going to want to get more information on that pandemic unemployment assistance. As John alluded to, April 12th was the eligibility that they released, but it's pretty much been difficult to roll out. They still are rolling it out. You can find unemployment insurance online, UI online, edd.ca.gov. But again, because of the fact that this is an entirely new program that's going through the states from the federal government, it's still having difficulties. So just keep an eye out. You can determine that on that site, edd.ca.gov, if you qualify for PUA or unemployment insurance in general. So take a look at that. I know some questions. LA County has its own order on real estate. How about OC, Riverside? They follow the state, so you'll just need to rely on that. But a lot of counties are mimicking one another, so just make sure you really keep an eye out. But again, Orange County, Riverside are mirroring the state. A 90-day forbearance, will it affect my ability to get a loan? It should not in the future, because of the fact that as part of that moratorium or statement or order by the governor, it allows for those who have the loan or going through delayed payment that they will not be dinged on their credit or other via penalty or interest payments. So you should be good on that front, but you do need to work with your mortgage provider. Property entrance social distancing protocol link. We got a lot of questions about that. The Safer at Home order for both the city of Long Beach and the county of LA. As an attachment, or at the end of it, they have attachment or appendix A, and that's the social distancing protocol. It's a 3-page document that you will need to post. If you create your own, it needs to be very similar to that. It's basically a checklist of everything you do, that you're not only following social distancing protocol, but the establishment is making sure employees are adhering to all the CDC guidelines. So that is part of the Safer at Home order for both the city of Long Beach, county of LA. You'll need to post that at any property or place of business. Name of the form you need to post. Oh, I went through that. Yep. Again, it's just called appendix or social distancing protocol. Are tenants allowed to violate the original lease and bring in pets? Basically, as John alluded to, we're in a new era. I don't know that we'll go back to the old landlord-tenant relationship. And so just know that the courts are open, as John mentioned, that a lot of these counties, the state, are really enabling tenants to have a longer repayment period, in many cases, do things they wouldn't normally do and be allowed to do so. So just know that you're not going to have a lot of recourse in the courts at this point in time. You can still document, but know that we're kind of in a new social, I wouldn't say even era, but is protocol about how we deal with these things. Thank you.
Perfect. Thank you, Christine. And a couple people want you to know that you are making them very happy by entertaining them. They're saying you're a riot and you two are adorable. So we got to give Tim and Christine some credit for keeping us all laughing. One more thing I want you to know, because I've answered it about 100 times in here, but in case you haven't seen me type it, all the questions you guys are asking about classes that John mentioned at the CAR level, all the information about the pandemic unemployment assistance, all the CAR best practices are all available at carcovidupdates.org. And I believe our PWR site has that linked as well. So if you log into PWR, there's a big red bar. You can't miss it. Click on it and it will have all the links that you need. So all of those classes on the new forms, any classes on risk management regarding COVID-19, CAR is putting out a ton of information. So please go to those two websites and find the information for yourselves and sign up what you need, because we don't need to spend time answering that question over and over again. So let's get down to some real questions that have been coming in that I think are important. John, this one's for you. We've had quite a bit of questions about farming. And can I farm? Can I go door to door? Lori mentioned not to, but what are the rules? And then secondary is, if I farm via direct mail, can I still mail?
Well, I think Lori hit on this pretty well before that. So there's actually two questions there. So let me take the second one first. Yeah, you can still farm by mail as far as I know. Just be careful how you do it. I know that that when I go get the mail, my wife is making me wear gloves. We put it on a certain place in the house and we let it sit there for a while. I'm not sure. She must have seen something about, the germs die after a certain period of time, I guess. So you can do that. Be careful, though, of Article 16. Be careful how you're doing your farming, because if you're farming generally, you're probably okay. But if you start farming in a very specific way and you're farming to people that already have listings, you may run afoul of Article 16 of the Code of Ethics. Secondly, can you go door to door? Why would you do that? I don't know, Ed, I mean, I know you're mostly MLS now, but you've been a realtor for a very long time and somebody I've always looked to for guidance, and Lori, you too. Why would you go door to door at a time where they're telling you to stay home? What, would you going to knock on the door and somebody on the other side is going to talk to you through the door? Is that how you're going to do it? Because if you open the door and you go in, you've probably violated some of the rules and you face fines, not to mention the fact that you're kind of going against what whatever the rules are that are being stated. So I just say be very, very careful about going door to door. I wouldn't do it. I certainly wouldn't let you in. Anybody else got any comments on that?
Yeah, if you want to report somebody, you can just send me an email and I'll reach out to the broker and the agent and let them know, doing that right now.
Right.
John, a lot of questions about what to do if the sellers refuse to leave the property during a showing or an inspection.
Well, you can't teach stupid. The fact is that everyone is telling, and this is something that the listing agents really need to talk to their clients about. Look, you may all think that that this stuff is all nonsense, that it's all of this or that, but the reality is that it's still the law. And whatever we think about the law, it's still the law. It still exposes you to risk, liability, and all that. So number one, as an agent, you need to have a heart-to-heart conversation with your clients about, and then make sure you document your file that you've told them that everyone, CAR, local jurisdictions, Christine mentioned Long Beach. I had that specific conversation with the city attorney for Long Beach, and she was just the most cooperative city attorney, frankly, I've worked with in a very long time. And all of them agreed, look, tell your sellers to go, I guess it's kind of like a boxing match. Tell the boxer to go to a neutral site. Either go to if you're on an HOA, go outside, go to the backyard, go somewhere, obviously do your protocols, but go somewhere, because really that's what you should be doing. If I'm the buyer and the seller's in there, you got to be thinking about that as well. There's a theory of law called negligence per se. And negligence per se says that if there's a legal duty imposed on someone and they violate that legal duty, then the issues of duty and breach are not part of the requirements for proof in a lawsuit. And therefore, the only issue is going to be, did what you did wrong cause the damage, and how much are the damages? I certainly wouldn't want to be defending that kind of a case, because a doctor is going to testify, yet you were a substantial cause of the damages, and then it becomes up to the jury what the check's going to be for. Okay? And again, if you do these things intentionally, I suspect, I don't know if Ed's been working with any of the insurance companies, I know I have, on business interruption, and they're taking very, very narrow views of the language in their insurance policies. I'm actually working on a claim. It's the first one where they haven't discarded the claim and rejected it offhand. So I believe that the insurance companies, simply because of the mass of claims that are going to come in, are going to take a very narrow view of a lot of the language of their policies. So just be careful.
Yeah. Something I'll just mention, I'm a practicing agent and I showed a property yesterday. The seller went for a run. It doesn't take more than 10 or 15 minutes to show a property, guys. So a seller stepping outside into the backyard, going for a walk, if they have an errand to run, going and sitting in their car. I mean, there's plenty of places they can go. I think that we're envisioning this as they have to leave the property for hours upon hours.
And don't go with your client. Meet them at the property. Normally, we tell you to do that for safety purposes. But again, follow the protocols. One of the questions, I know it's not a question that's pending, but I know that it's come up in your office, Barbara, and it's come up in a lot of areas. How do I do a visual inspection if the seller won't let me in and I'm representing the buyer? And so we're going to put together a little bit of an article, but if they won't let you in, obviously the listing agent needs to remind the seller of their contractual obligations, which haven't changed. But if they still won't let you in, do what you can. If you've got if you've got something virtual, then go back to it, take a look at it, make it clear on your Avid that you're doing this virtually because the seller won't let you in. You've been to the property more than likely. What do you remember? Make it clear on your Avid form. What do I remember about? Well, I remember there was a crack in the driveway, or I remember there was a stain in the living room, or something like that. And then make it clear in your Avid that what you're doing is based on recollection, not present recollection, but a prior recollection. Maybe even put how long ago. For somebody like me, who's of a more advanced age, that means anything more than 10 minutes ago, I probably have already forgotten. But for somebody that with a good memory, that may not necessarily be the case. So just be careful about these kinds of things, because that's what's coming up. The big stuff's pretty much been resolved. It's these sort of day-to-day issues that are coming up a lot.
Ed, there's some questions on office exclusives, and they're basically saying, may I maintain the exclusive state for the term of the listing? I know you messaged a few of these answers, but it's coming up time and time again. So
sure.
Explain how to
Yes.
stay an exclusive.
Yeah, you can keep if you're, again, the trigger now to put it into the MLS is, did you publicly market it? So to the extent that you're not publicly marketing and all of your communications are going to your existing clientele and for prospective buyers for which you have an AD form, then you can keep that property in that register status as long as you want, all the way up to the time that it expires, or until it even, past it selling. The triggering point for mandatory submission under this rule will be, did you publicly market the property? When you do that, it's got to go into Coming Sooner Act.
John, someone wants to know, a lot of tenant questions. Can we still legally start the 60-day eviction process with the date to be determined?
You can. I'm not sure. I'm not aware of any restrictions on that. But again, better be aware of your local jurisdiction's rules, because if there's been some kind of a moratoria placed on or a deference placed on rents, then you may be giving an invalid 60-day notice. If you're looking to get the tenant out, it's not in 60 days. It's probably not going to happen. Also, keep in mind that AB 1482 is still the law, and so you can only give eviction notices under certain limited circumstances. There are still the for-cause evictions and still the not-for-cause evictions. If you're giving a 60-day notice because the property is going to be taken off the rental market at some juncture, for example, so that the new buyer can occupy the property, you're going to have to be very careful about that. And again, make sure that you understand your local jurisdiction's rules and also state rules for evictions. You're not going to evict people, probably. You're not going to be able to get into court under any circumstances, probably until the late summer or early fall. That's pretty clear, I think, Ed, that the courts have, under the Judicial Council's emergency orders, they're going to take criminal cases first. So when they open up again, whatever that is, they're going to take criminal cases first. They're going to then take evictions for non-payment of rent under legitimate circumstances second, and then they're going to start opening them up to civil. And so if you're looking to evict a tenant, you may or may not be allowed to do it. And if you do it, you may not be allowed to do it as a priority matter.
Yeah. So someone's mentioning they have an uncooperative tenant in a fourplex that they've listed and currently in escrow. Tenants not allowing access for appraisal or inspection. What rights does the tenant have versus the landlord?
Well, again, that's still being thought through. I talked to the city attorney in Long Beach about that very issue, because it's come up in a couple of different areas where, for example, I need to make repairs. Well, if it's your own unit and it's a health and safety issue, there's probably ways you can give a notice and get in. But again, it's still unclear because of the COVID restrictions on social distancing. An issue came up, for example, what if I need to get into apartment number 1 because the pipes that are in apartment number 1 are affecting flooding in apartment number 2? And again, I don't know specifically the exact answer to those questions. Again, you need to remind the tenant that regardless of the fact that they're playing games themselves and that they are exposing themselves to a eviction, whether it's immediately or down the road, because under the 1482 guidelines, failure to allow reasonable access to a property after proper notice is grounds for eviction under the for cause, and they will not be given a relocation fee. So, but again, why would you be so stupid as to not let a landlord in to fix something where you yourself are complaining that there's some kind of a health or safety problem? I think all that does, it certainly doesn't help the tenant. It certainly is not going to, if the landlord documents his or her file correctly, certainly not going to affect the landlord. And all it does is make for an uncomfortable place for you to quarantine yourself. So I think that's fairly foolish.
There's a couple questions about offering tenants money to move out, things like that.
Well, I don't know what the question is, but I'm not aware of any restriction on cash for keys. But boy, I wouldn't give the cash till I got the keys. Because if you enter into some kind of an agreement and then they rescind the agreement or renege on it, how are you going to enforce it? So if for some reason a tenant is willing to move out, we had a situation come up where the tenant had asked to move into a smaller unit because they couldn't afford the rent on the bigger unit anymore. Those kinds of questions, again, work it out. Document your file. I know people are reluctant to pick up the phone and call people like Ed or I, but do that. Get some guidance. Help people, put it in writing and then work it out. But yeah, I don't see any restrictions on cash for keys right now. I don't know if Tim or Christine have seen anything come down the road from any of the jurisdictions, but.
No, I just would be concerned that you're still adhering to AB 1482, as John mentioned,
right.
That not superseding that or in violation of that as a result.
Right.
Because you guarantee that right now is troublesome, but then once we even go back to normal circumstances, you're going to have a lot of people who are filing claims under that and under the tenant relo issues right now with everything. So you're going to issue a 60-day, you better have good grounds, and I would even contact CAR legal hotline if needed due to the particular circumstances you're in. Or
your own attorney, because the hotline is going to give general, I agree with you, by the way, everything you just said, but also don't be penny-wise and pound foolish. I mean, if you've got a legitimate issue, there's, first of all, the landlord is not going to be in the best bargaining position in a lot of jurisdictions in California. So my suggestion is talk to your lawyer, talk to somebody, get some good solid legal advice on how to deal with these issues, because again, every set of facts seems to be a little different than every other set of facts. And so just be like I said, the landlord-tenant issues are a lot more problematic in a lot of ways than the transactional issues, because we're starting to see some commonality in the issues that are cropping up, whereas the landlord-tenant issues are all over the place.
Yeah. A couple people have been asking Ed about can someone cancel the listing when the status is coming soon and the 21 days is about to expire so that they can put it in as coming soon again? And again, I know that this question is leading towards how do we break the rules, but I think some of these questions are what they think their colleagues are going to do, not necessarily what they're going to do.
Of course. This is a friend of my friend thought about this.
Yes.
I get it. And again, with some of these what ifs, I'm going to need to see them actually occur and then tackle them as they come up. Remember, we operate at CRMLS the citation policy, which is our compliance department issuing, if you will, like an immediate ticket for a violation. Nothing stops either CRMLS or you as an agent if we start to see some kind of practice that not only violates the MLS rules, but also violates the code of ethics, from actually bringing a separate action directly with Lori and filing a disciplinary case. And that's what I would probably recommend is something like that. While we don't have you can't write a rule for the creative nature of you guys as real estate agents on how many ways you can find to break certain things. But we always have the ability to go in front of a 3-member panel of other agents And trust me, if we do that at CRMLS, and I've had to do it one time for what I consider to be a very extreme case, where we actually filed a disciplinary action instead of moving forward with a citation. And we add to it code of ethics violations, and we are also then at that point not capped by the citation amount. So I can tell you the one time that I was involved in a matter and the situation was extreme, we did get the NAR limit.
Which is a lot.
Which is a lot.
I believe that once this rule goes into effect, Lori and I have had this conversation, and we've actually had it with the professional standards hearing officers, that in addition, if Ed sends us something that says this guy's been doing it a lot, I believe that we're going to be dealing with an ethics violation as well as a simple rules violation. You know, if somebody gets warning after warning after warning, I suspect that Ed's going to send that to Lori, and then Lori's going to send that to grievance. Grievance is going to find a potential violation of Article 12, and maybe even one which says I'm doing it for the benefit of myself, not for my client. And then we're going to have $15,000 questions come up.
Well, and I think also any violation of the MLS rule here, I think, is a de facto violation, or at least arguably, of Article 3, right? The requirement to cooperate. Yeah. Right? So right away, any violation of one of these MLS rules for a realtor, if we go the route of, you know, a full hearing, you are at that $15,000 number. Realize if we go to a full hearing, the citation caps are no longer in play.
I agree. I think that you're going to, I think that the 3 is a gimme, 12 is a gimme in most cases, 1 is a real potential, and maybe even 2, because you're misleading people.
Right.
And of course, that always brings in, whenever you get to the point where you're doing that kind of activity, 11, which is the, you know, don't be stupid, don't fall below the standard of care article, also comes into play. So, and those are some pretty big fines, and possibly suspension from both the MLS and the board, and potentially, you know, in some cases, although it would have to be pretty extreme, it could be expulsion.
Yeah. Can I just say, at the end of the day, please just follow the rules. Like,
right. Is it really that hard?
Not that difficult.
Ed and I have been blessed to live very abundant lives because people don't follow the rules.
Yeah, I
That's true.
You know,
meant to not only protect us as our real estate community, but to protect the client. You know, I mean, I see some questions and I get concerned about us trying to figure out all these ways to get around the rules, and the rules. So I hope everyone is learning the rule and understanding how to follow it, which is
again, I believe, and I don't know if Ed agrees with me, but I believe we're going to see a glut of different kinds of claims, possibly some we've never seen before, many we've never seen before, when all this is said and done, because the plaintiff bar hasn't really weighed in yet. And they're sitting back there watching and waiting. And although the ADA group has already started to file lawsuits and make claims, I think we're going to see a lot of claims based upon a failure to adhere to a standard of care that says you fail to put your client first. You put yourself first. You played, as you just said, Barbara, you're playing games. Go ahead, because you know, we'll be able to travel again, and we all have things we have to pay for. And so if you want to make lawyers rich, go ahead, take a shot. I just think it's incredibly stupid to do those kinds of things, and particularly at a situation where, you know, everybody's sort of on thin ice anyway. And for you to take advantage of a situation knowing, you know, you could be putting people in harm's way, knowing you could be violating rules, I just think is an incredibly risky thing for you to do.
Yeah. Well, I was speaking about the coming soon, but, you know, those rules will be around forever.
Period. All rules.
Perfect rules won't be around forever. Okay, a couple of questions on staging, John, and why is staging not allowed? And then someone asked, if my client's demanding that I stage their house, can I tell them no?
For me?
Yes.
Or for Ed?
For you.
Well, you can do virtual staging, number one. Those things can be done. I have no idea because I was able to attach my first document to an email last Saturday, so I'm just thrilled that I've gotten that far in the technical process. But you know, you can stage virtually, and of course, CAR's position on a fallback, everything should be done virtually wherever possible. If your client's demanding that you do the staging or that you bring in people, again, take a look at your local. I don't think you can do that, for example, in a jurisdiction like Long Beach, Christine. I think the rule's pretty clear that you're probably not going to be able to do that. I just think that, you know, there's going to be time for all that. Of course, those people that absolutely positively have to sell their house, that there may be some ways that you can carefully come up with a solution to the problem. But for most people, I don't see how it's going to be done. I mean, if your client said, well, go ahead and disobey one of Ed's rules, or go ahead and disobey one of Lori's rules, and would you do it? No, you know, just you can't. The bottom line is right now, you're trying. To me, if I put my client's interest first, that includes their interest in staying healthy, being safe, and not violating local jurisdiction and state and federal law. To me, that goes part and parcel. You don't want to get your clients in trouble, so that's part of putting their interest first.
And a really important one that was just asked is the owner wants to move back into the home for financial reasons that they've currently rented out month to month over the past several years. Is the owner able to do so? The tenant wants to stay.
Nope. You can, but you'll be living with them because you're not going to be. Again, let me say this slowly. You aren't going to be able, absent some extreme emergency, which that doesn't apply, absent some, you're not going to be able to get an eviction order, which means you cannot self-help and get them out until probably late summer at the earliest, maybe late summer or early fall. So that's just the way it is. I'd like to open my bar back up. I can't because I have orders, right? There's rules in effect that don't allow you to do certain things, and that's one of them.
The couple of questions have been asked about what can we ask for prior to allowing someone to see a house? For instance, they're asking, can I ask for their pre-approval before the seller allows them to see the house?
Yeah. You could answer that question, Barbara. That's a great, I mean, the way most of the way CAR, NAR, Long Beach have all said, and pretty much most of the jurisdictions, is don't let people go to the property minimally who are not quote unquote serious buyers. And that's been defined, people that have been pre-qualified. In some cases, some listing agents are demanding a contingent offer be presented first, contingent on viewing the property, of course. And so whether you're in Orange County, whether you're in Long Beach, whether you're in Los Angeles County, I think those are just good rules to follow. That serious buyers only, at least for the time being. Looky-loos, no.
Absolutely. And to be transparent, that's how we're handling our business. And that's why John mentioned that, because I've been sharing that with him. And subject to inspection, subject to showing, full and complete offer, proof of funds, you know, the whole bit, because this isn't a time to just have, as I say, a train of people through the property. That's irresponsible right now, guys. Right. And on vacant properties, how we're handling it is I put a CBS code on all of my vacant, well, all of mine. I have one vacant listing and one coming up. I put a CBS code on the lockbox, and I will not release that CBS code to the agent until I have the PEAD form. And that's to protect that I actually get that document before they go to the property. And then on a property that may have a ton of showings lined up, I'm spacing them all 30 minutes apart, and I'm not giving out the code until 5 or 10 minutes before their showing time to prevent them from just, you know, all being at the property at the same time. And you may say that that's too much work. Well, at the end of the day, I feel like that's our standard of care responsibility, is to step up our game right now and change the way we do things to accommodate these issues. So it can be done. I think we just have to do it responsibly and respectfully within the rules.
I have a
With that
question
being said,
for
real quick, John, if I can jump in on the showing issue real
please.
quick. One of the things I would encourage you to do too at CRMLS, we do have showing time, available as a tool. It's an excellent tool. I honestly, again, I'm still a broker and I use it all the time. It's a fantastic resource. And when the COVID-19 thing came out, from a technological perspective, showing time actually blocked the ability to overlap your showings, right? So that's another way to use a technological tool to maybe help in some of your risk management and some of your processes, right? So if you haven't used showing time before, going in as a listing agent and setting up the parameters and the rules around your showings, it does allow for you to limit, access points and things that they can be given inside of a confirmed showing instruction, as an example, right? So it's a great tool and a resource there that you maybe should be availing yourself to, especially if you got a little extra time right now to learn how to use some of those new tools.
I think I have a question. Can I interject my own question? Is that against the rules? For Barbara and for Ed mostly, actually. I'm seeing a lot of practices being implemented now that I think are going to become part of. Phil mentioned before we're seeing the wave of the future and training and things like this being the way we're going to do it in the future. And I agree with him. I think that's a good idea. I think that there's some practices being perfected now by people like Barbara that and people that she's been talking to and others that I've seen around my boards, I think that are going to become part of the way you do business down the road because they make perfect sense. And it's going to be interesting to see, and I don't know if you two agree, that we're going to start seeing we're a lot of sloppiness, with all due respect to the real estate industry, has entered a lot of our lives in a lot of different ways. And all of a sudden, we're all slowing back down again. And I see some really good stuff coming down that I think is going to survive all this and become a great new way of practicing real estate. What do you guys think?
Yeah, as far as it relates to the use of the MLS and learning about a property and accessing a property, I could definitely see this time period. People are being forced to use some of the tools, frankly, that have existed for some time, right? Like I said, when I bought my first property out here in Tennessee, I used a Matterport, and I was able to on my computer sitting 2,500 miles away, I was literally able to walk myself through the property, grab the screen, turn around, look up and down. I was able to see those connection points from a living room to a kitchen, to a staircase, into a bedroom. And I got extremely comfortable with what this property was like, even though it was thousands of miles away, where I was totally fine putting an offer in. I can definitely see that use of technology, and as people who maybe kind of weren't familiar with those opportunities are now forced into that. Think about that for your seller, right? One of the big challenges and pull for these iBuyer concepts, right, is it's easier to show your property. It's a hassle to show your property. Well, imagine now that, that becomes the typical way that the looky-loo looks at your home from their own computer without ever bothering you. And the only people you let through the door are those that have either already made an offer or are about to make an offer, right? And so I think that's definitely a step that is probably better for both the buying and selling consumers, that may be with us forever after this event.
Yeah, I echo what Ed said, and more importantly, when I've sat on listing appointments for years where sellers have said, now you're sure only qualified people are going to see the property. And we used to say, well, we don't always know those. We can ask the agent questions, but we're not necessarily going to get those details till they decide to make an offer. And I think what's happening during COVID-19 is it's proving to us that we actually can do the reverse. Now, I do think while we're in an inventory shortage and demand for buyers or a demand for property is very high by buyers, these systems will work. But I think if we float into, right, more of a seller's market or a buyer's market, too many homes on the market for, too many buyers, then that may not work as well, right? When you need any buyer you can to see your property. you know, right now, I got 7 offers on a listing yesterday subject to interior viewing, and I probably have about 5 more right now because that's the market we're in. But I think when we don't have that inventory shortage, it may not work as well. But I think we're opening up our minds to virtual appointments. I'm doing virtual buyer consultations that I wouldn't have necessarily done before, but it makes it easier because we can wait till that 7:30 when the kids are quieted down and they're watching a movie and mom and dad can talk to me on the computer. Before, they would come into my office, they'd have to get a babysitter, they'd have to worry about evening activities. So I think we'll see a lot of that flexibility open up, which is, like Ed said, frankly, some welcome changes to our industry. So I echo, you know, what both of you are saying. I think there's going to be some positive things that will come out of this.
Yeah.
So we're going to get ready to wrap this up. So I'm going to give all of our team here one last chance to add any final comments or anything you heard. Lori, I'm going to start with you.
Yes, I would just caution you, if you are going to do a virtual through MLS, make sure it's not branded.
Yes.
That's a finable offense. But Ed, correct me, if they do a virtual tour on your own through your own Facebook page, that can be branded.
Correct. So the rule that we're allowing is we are allowing an unbranded virtual tour in public remarks, right? The idea here is so that when it shows up on an IDX website or in some other location, it'll be easier for a consumer to interact with it. And a virtual tour is a link that is always available, which has some kind of, you know, photographs or video or some other way of seeing a property. That's distinguished from a virtual showing or a virtual open house. A virtual showing or a virtual open house is a set appointment time, right? And that is something that is set directly with the listing agent, and it has a finite time. So if you have a virtual open house, it would be on Saturday from 1 to 4. I'm going to be available. I'm going to have a Zoom meeting link open, and anybody who would like to hit that link button will be able to get access to me, my nice bald head, and we can ask me questions about the property that we're touring, and I can walk around maybe with a phone if I'm in one of those jurisdictions where I can physically be in a property that's vacant or something, or maybe my seller's involved by holding the camera, right? Some kind of interaction that happens at a set time. For those types of things where it's a set specific time and tied specifically to a link for a meeting, a Facebook link, a Zoom link, something like that we are allowing to be branded, because obviously it's impossible to do an interaction point without that, you know, that branding. So we're trying that out to try to, again, accommodate this kind of unusual situation and make sure that agents are able to get the opportunity to show those properties in this kind of unusual time frame.
Yeah. And I just saw a couple questions pop in that I think are very important. I want to make sure we cover them at this last minute. A lot of agents are asking about the PEAD form, and some of the people apparently don't know it exists. That is a very important form that you all should be using for anyone that accesses the property. And someone asked, how do agents sign it? Well, it very clearly says signature spot, and at the bottom it says, if this form is being signed by an agent or broker, you put your company name, your license, the date. It's very important that everyone that enters a property, buyer's agent and buyers, use that form. And John, I know, will echo that.
No, it's probably the most useful and at the same time most controversial of all the new forms, because it's a declaration. It's wordy. So my suggestion, number one, I agree with everything Barbara just said, so do what she just said. But number two, it's being revised. So I don't know what the revisions are. I haven't had time to go in and look and see, and because there aren't red line posted, I'm going to wait till Friday to find out what the changes are. It's not a mandatory form, so it doesn't have to be signed. Just be very careful about that. If somebody refuses to sign it, we've said at our firm, and I believe that Ed, we haven't talked about this, but if somebody's saying they're not going to sign the declaration, that's a red flag for you to wonder, why would you want to let them in the first place? So you would be well within your rights to say, if you're not going to sign that declaration, which I have sent you ahead of time, well in advance of our appointment, because no one's just showing up at property anymore, hopefully, I am going to not let you in. You can make that very clear. Either you sign it or you're not going to get in. If it's an inspector or somebody like that, maybe a little bit different situation. I was talking to the president of CREAIA, and he indicated that, look, just get it to us ahead of time. Each inspection company, each inspector individually, going to make up their own minds. The other thing, of course, I've talked to some brokers. They'll come up with their own short version, basically a simple declaration. I do not have. It's that last paragraph in the declaration. So again, I think it's a good form. I think it gives you a lot of protection. It's a great risk management tool, and while it's not mandatory, but I wouldn't let somebody in if they weren't willing to sign it.
And I would also make a recommendation from the MLS perspective. If that's going to be a condition, right? You, as a listing agent, you have that agent comment section, and you have every right to put a condition on under what scenario is someone allowed access to this property, or how is that showing going to happen, right? So if you're going to require that form, go ahead and put that right there in that agent comment, right? Just like you do with other comments about showing restrictions or other restrictions about presenting offers, things of this nature, right? So use those fields to your advantage.
Yeah.
And I don't believe that would be a violation of Article 3 or Article 1, which are the showing articles. I just think, look, this is a special time, whether, regardless of your political views, this is a special time from a legal perspective. You got to protect yourself. You got to protect your client. And that form, which I believe will go a long way to setting the standard of care in the state of California, is an essential form. And talking to the young attorney that's been working with me on all of this, Cody Bellmeyer, we both agree 100% that, boy, it sure is a major red flag if somebody's not willing to sign it.
Yeah. Well,
send it ahead of time so people don't just get the form and have to read it on the fly. That's something you shouldn't expect anybody to have to do.
Well, and it goes along with the new listing addendum. The RLACAA actually mentions it in there that the sellers, you're agreeing with the seller ahead of time how you're going to handle showings, and one of those conditions is that you get a PEAD from everyone who's in the property. So you got to make sure you're acting how your seller wanted you to. Yeah,
I think that the first thing you do is, if you haven't done it already, is sit down with your seller virtually, if you have to, or sit down like Christine and Tim are doing now, so far apart, and go over that form. Whenever you see the word addendum and it's signed, that means it's become part of the contract. So it's an addition to the contract you already have with your seller. But even if you don't do that, at least go over the list of issues that have been put in there by CAR, because it's a pretty complete list, and I know that that's part of what they're going to be revising to maybe even make a more complete list. So I just think it's again, be smart. Be smart.
You've got the mic right now. Any last comments before we wrap up from your end?
I just said it. Look, treat people like you would want to be treated. Think about the fact that put your family in the situation you want to put other people in, and ask yourself, would I do that to my family? Would I do that to my loved ones? Think through how to best protect your client and everyone else involved, whether your client's the seller or the purchaser. And then more than ever before, cooperate with each other. Think ahead, make appointments, do those kinds of things, and just be smart. Because whether you're a nice person, which hopefully we're all becoming a little nicer as we slow down a little bit, or you're one of these people that's trying to figure out how to game the system, we're all going to be facing an unsure future, both economically and legally, down the road. So you just certainly don't want to be one of the test cases.
No. Ed, anything to wrap up?
Yeah, just a couple of things. Some additional resources on the Clear Cooperation Policy. If you go to crmls.org on that homepage, kind of towards the bottom right, we've devoted a specific page to the resources for the clear cooperation policy. We're continually adding to the frequently asked questions section on there. And so that's a good place to go if there's some other questions you have about how that policy is going to kind of roll out and what's going to happen with it. I guess my point here would be to be a little encouraging of try not to fight the policy. Guys, it's not that big of a deal. Put your property in the MLS, right? It's good for your sellers. It's good for you as buyer representatives to have access to inventory. It's not that big of a deal. They're really not that big of a change. Yep. And with regard to kind of, what's going on, it's okay for things to change and deals can still close, right? You guys are going to have to do some work. You guys might have to be creative. You may have to do some things a little bit different than you've done them in the past, but go on those, do your Zoom listing appointments, work with buyers, through the technology that's available to you, both through the MLS and others. And what you do is critical to our society coming back and being what it needs to be, right? I would encourage you to look at that preamble to the Code of Ethics, right? Yeah. Take a minute to read that right now, because right now is you guys are needed, right? You're needed in the civil society, and the role you play is critical and important. And everybody recognizes that. So stick with it and still get some deals done.
Ed, I want to echo what you said. I didn't mention it earlier and I forgot. For those of you who are frustrated by this rule and think it isn't good, think about the power of the coming soon section that now only realtors have access to. I mean, yes, someone can post a coming soon on, Facebook, a realtor can, but we now have the ability to be able to tell our clients about some upcoming listings that they may not get to know about, right? Like that they can't just go on Zillow and find. There's some powerful stuff within this new rule if we just look at it differently instead of trying to figure out ways to get around it. Christine and Tim.
Yeah, so I was just gonna say, we have over 30 cities. I think we do a good job about monitoring what's going on in each city when it comes to real estate, but just in case something's happening and you wanna make sure we know about it, please feel free to reach out to us. My email is going to be easier than Christine, so I'll give out my email is tims@pwr.net. So if it's maybe, of course, we're following Long Beach and Anaheim and Santa Ana, our big cities, but maybe one of the smaller cities, something's going on, just to make sure we know about it. Feel free to shoot me an email. Again, tims@pwr.net, and we'll follow up and make sure we know exactly what's going on in each of our cities related to real estate.
I have just 2 items since Tim took all the glory. One is, John, you'd be a good politician. You always say, I'm going to make it brief, and it's always another 20 minutes. So you'd be great at that. And the other is, I think it's, as Ed mentioned, we're resetting practices across the board in our daily lives, real estate transactions, landlord-tenant relationship. And a lot of these take extra time to understand and implement, but in the long run, it's really going to be impactful, and those who adhere to it are really going to see a difference in terms of their client interaction. So keep up the good work. Thank you to everyone.
Yeah, thank you guys for everything you've done for our members. We appreciate you. Phil, you get the last word. I purposely didn't leave it to John. I left it to you because I knew it would be short because Phil's hungry for lunch.
Well, I just want to remind everybody, we are here. We are open to help you. Give us a call. I'll tell you, prior to what's going on now, we would receive between 400 and 400 calls a day. That was a normal day for us. Every day, 400 to 450 calls. Now we're getting 200 to 250. It's less, but we're still here. Give us a call. We'll help you in any way we can. We'll go that extra step. So use us. That's what we're here for.
Perfect. All right. I think that ends our webinar for today. Thank you all for joining. We appreciate all of you. Thank you to all of the panelists. You guys are all amazing. And I assume, Phil, will be doing these again soon.
Yes, we will. Thank you.
All right.
Thank you.
Hey, thanks a lot, everybody.